related matter is already still pending before the Honorable Apex Court. And the matter is item 4, my lord.
Dilip Kumar Verma?
Yes.
It's customs not.
Customs appeal, right? Yes.
The connected, my lord, appeal is still, SLP is still pending before the Honorable Apex Court.
Okay, yes. After 6 weeks, with any outcome.
Yes.
As is submitted, that the matters, similar matters pending consideration before the Honorable Supreme Court is up to 6
In fact,
weeks.
against an order passed in this matter, my lord, they've gone SLP.
One of the orders we have challenged passed by the Honorable Court, my lord.
Formally, as is reported that an ancillary matter arising from the incident case is pending consideration for the Honorable Supreme Court list for 6 weeks to await any outcome. By what order you challenged?
But there was an order, my lord, where we had
The
said
monetary
that
limit,
this
my lord.
monetary,
We are saying that it falls within the monetary limit, so department is not supposed to file, my lord.
there was a
Right,
monetary cap which was set by the government, my lord.
So you file an appeal.
So that plea they have taken, my lord, that was rejected. They've gone on SLP, my lord. Against that.
Okay. Yes.
Supplementary list item number 1.
But this is also a customs appeal, my lord. There is a delay of 105 days. I'm praying for notice today, my lord, on continuation.
Yes, dismiss customs appeal number 1. Huh? In this case, correct with Dr. Mazika. There is an application for consideration of delay in preferring the connected customs appeal. But the stop delay is of. That's correct. This one totally 105 days.
105 days.
105 days stop. Stop. Next issue notice returnable in
3 weeks.
3 weeks.
Take
Steps
step.
taken,
3 days.
but it's 80 within 3 days. List on so and so.
Daily list item number 1. Lordship, I'm appearing for all the respondents in this matter. I have just been appointed to represent the respondents in this matter.
You become standing counsel income tax now.
Yes, Lordship, I'm a senior standing counsel for the North.
What's happened to Mr. Kayal?
Lordship, he has been designated as a senior advocate, and as per the Guwahati High Court rules, a designated senior
Can't be standing
advocate
counsel.
cannot be a standing counsel.
So what do you want today?
Lordship, I need at least 3 weeks' time to seek instructions on the matter.
Interim orders there?
No, Lordship.
No, Lordship.
MS P. Agarwal, General Counsel, submitted that she'll be appearing the matter henceforth on being engaged by the respondent. Stop. She prays 1 or 3 weeks time to obtain instructions and to file affidavits.
Published.
2. In item number 2 also, I'm appearing for respondent numbers 2 to 5.
Yes.
Lordship, I am for the petitioner here.
Right. So you same
Lordship,
prayer.
in this matter also, I have a similar prayer, Lordship. I have just
Yes.
been endorsed with the matter yesterday.
Same prayer on interim order if any shall continue next day. Yes.
Deeply obliged.
Deeply obliged, Lordship.
Hearing.
3.
This is Meghalaya College teachers matter, my lord. In this matter, my lord, there are certain amendments which have been carried out in the rules recently, my lord. And on 9th April and also, my lord.
As per the last order, they have to file a reply to our objection, my lord.
Yeah, yes, my lord. Some amendments have been carried out in the rules, my lord. So I am seeking some more time. So on 9th April and also, my lord, on 28th April, my lord, some notification has been issued, my lord. So I need some more
Meanwhile,
time.
my lord, they have constituted another BOT, my lord, consisting of 10 members now.
Because we have.
Let's address that when the matter comes.
Yes.
Let them put on record.
Yes, my lord, we'll place it.
General Advocate General has submitted that as there are certain developments in the matter wherein the scheme has been
Amended, my lord.
that will be amended.
Amended.
Has been amended. So he prays that he be allowed to bring the same on record by way of an affidavit before the next day.
Yes.
Just after 2 weeks. Yes.
It's now what we instructed is, well, your lordships have granted them time to file a reply.
Now they changed the BOT.
Because they were having some objections. We have put it in line with the objections now.
Never ending. Sorry. Yes.
Well, like, we don't know what to challenge and what not to challenge.
Exactly. In the
No, my lord,
papers,
because
we
they
could-
pointed out some,
we
they
can't-
pointed out
we-
some
we can't
inaccuracy.
papers understand what is. Anyway, these are
Well,
public,
may I pray that your lordships hear the matter, and till then the government, my lords, does not keep on shifting its
No,
stance.
it's not
Because
this. We
the
are
difficulty becomes,
no,
I don't know
on-
what is to be argued before your lordships.
My lord,
We come with
their
something,
whole-
my lords, they'll go back, they'll take time to file a reply, they'll go back and change it.
No, my lord, what has happened, my lord, that my friend pointed out
Anyway,
that
let's have it after 2 weeks. Yes. That after we put on record.
we have take remedial measures. That is also not my friend is happy.
You won't allow you to take remedial measures.
Yes, they have taken and now said that they want to challenge it.
Well, it's whether it is remedy or whether it is
Five.
Yes.
finishing of the cake itself, I don't know. Oblige.
5.
5 minutes connected.
5 years.
6.
Together.
May it please your lordship. Your lordship, in this matter, kindly operate for 3 weeks. Your
Lordship, this matter can be heard because on the last occasion since from
Yes.
the 2000 on the 2025 and 2000 they have been repeatedly making a statement that the matter is under active consideration. Till now they have not done since from
Now it's under
the order
inactive
dated 07
Where's
2025.
Mr. D? Call him.
Your lordship, he have some unavoidable circumstance.
What's unavoidable? There's Mr. Depp. I can see him standing at the door. Call him here.
Your lordship, he went for his mother medical treatment.
Yes. You're not ready to the matter today. It's been
Your
prolonged
lordship.
enough.
Your lordship, the respondent has filed a representation.
That we have given a sufficient time that in compliance with the order dated 26/03/2026.
What happened to representation?
We have filed it and they
What's happened to that, Mr. Depp?
We are
where this case?
receive what has happened to that presentation. There was decision to consider his case.
No, consider yes. What happened?
Also, we are yet to obtain the clear instruction what happened to that EC meeting. I'm just praying for some further time. The Lordship would be kind enough.
that consideration since from 2025 they have been making a statement.
Okay. Yes.
Because perhaps because of the situation and the changes of the.
It was heard. Maybe it might go the other way. Yes, Mr.
I'm
S.
just praying for
Depp.
2 weeks, Lordship will try to.
Some praise that he allowed 2 weeks for that time to obtain instructions. It is noted this matter has been prolonged for a considerable period of time. So expected on the next date that specific instructions be received.
Hello, bless. Good day.
Must bless Lordship.
7.
May it please your lordship. Lordship, hearing was concluded, my lord.
Whether no
My lord will be filing in the course of the day, my lord.
Yes, Mr. Fukan.
My lord, arguments were already heard. It was reserved. Now he says that the tribunal has been constituted, rightly constituted. I did find out on January 21st, 2026. Subsequently, I think they have already started hearing matters in the month of March. Yes, in Guwahati itself. However, my lord, at the time when we approached the court, there was no tribunal existing. So whether that power can be taken away by creation of a tribunal under 226 would be a question that will have to be decided by your lordships. Secondly, my lord, at that point of time, because of a non-creation of a tribunal, we have proceeded the matter on the President. Lordships had also given interim orders passed on these matters now. So all I'm requesting is,
you'll have that protection until
Yes.
you approach the tribunal.
but the problem is, my lord, if the pending matters are not transferred, then your lordships will have to decide it, because I don't know what the notification says. He's not given me a copy of the notification.
Doesn't matter if the tribunal is already constituted. We'll give you protection.
But they will have some kind of a protection, my lord, I think, in terms of matters which have been filed. So if I can be given a copy of the notification, I'll at least be in a better position.
Mr. Fukan, Arif Fukan today submitted that the IT-80 tribunal will constitute in Guwahati since January 2026.
Yes, my lord. This is my, I don't have the
Questions have arisen
notification.
whether this court can proceed under 226 or whether this question have arisen whether this court should
Proceed.
proceed
Yes.
in considering the matter under Article 226. Mr. Jendranja appraised
We'll be filing in the course of the day, my lord.
He'll file the written submissions in the course of the day. So he also undertakes to. Have you given a copy of the notification and written submissions?
Lordship.
To supply copy of submissions to these?
Yes. We'll also, if your lordship writes, we are ready with that. We'll file it in course of the day itself. Extremely grateful.
Otherwise, there's no point. Yes.
8.
Yeah, but the goal is concluded submissions.
My lord.
It's my reply. It's for reply.
You reply today. How long will it take? 15 minutes.
Slightly longer than that.
Yes.
My lord, primarily 4 pleas have been taken, my lord.
One second. Yes. Yes.
The first plea that is taken is that adjudication order came about 8.5 years after the issuance of the so-called notice.
Today is 7th?
7th.
Yes. Yes.
The second plea that is taken, my lord, that the DGCEI, which is located in Delhi, could not exercise jurisdiction in respect of Meghalaya. Third plea taken is, my lord, that they have the investigating officer had interest in the outcome of the adjudication. And the fourth plea was on merit, my lord, that
You mean the investigating officer had interest in the sense of the doctrine of bias?
doctrine of bias, my lord. That was the third plea taken, my lord. And the fourth plea was on merits that the services rendered by Argis is not covered under the life insurance business, my lord.
Yes.
So, my lord, I'll try to counter these points, my lord. I'll start in the reverse order, my lord. I'll first address the fourth
Merit.
issue on merit, my lord.
Okay.
My lord, kindly turn to page 286, my lord. But this is adjudication order.
1 second. Yes. Yes.
Well, this is adjudication order. It starts from page 274. I'm referring to page 286, my lord. What is the relevant period here for which the service tax is in issue, my lord? So, lordship will see the table. It starts from 11/12, my lord, and till 15/16. Now, lordship noted during the course of submission by the petitioner that service tax regime changed in 2012, my lord. Earlier, it was a positive list regime, my lord, and post 2012, it is a negative list regime.
Yeah.
1st July 2012, the negative list regime came into being, my lord.
Yes.
So the law was different in the positive list regime,
Yes.
and very forceful argument were made, my lord, that this is not covered under the life insurance business. And 66DA was shown to your lordship, my lord.
66?
As it referred to, my lord. The page.
66B or D?
Sorry, my lord, page 366, my lord. Section 66, page 313.
313?
313.
Yes.
As it originally stood, my lord. So, lordship, under the positive tax regime, my lord, positive list regime, certain services were defined, my lord. And any person rendering those services only were liable to pay service tax. And our case is, my lord, the RGs was rendering the service of life insurance business. Life insurance business is one of those services which are in the list, my lord. Now, after 2012, my lord, a negative list came that all services are taxable now, except some.
Yes.
So there are two parts of argument, my lord, whether the services rendered by RGs is taxable or not.
Yes.
In the positive list regime, my lord, the plea was taken that it is not a life insurance business per se carried on by RGs, my lord.
Yes.
And they took to the definition of life insurance business.
Where's the list?
I'll point out. My lord.
66B shall be levied. Okay. And then, so the amendment was once in 2012
So, my lord,
by section 66.
so, my lord, that argument is relevant only for pre-2012, my lord.
And the first
The life insurance
the first assessment year is 11-12.
11-12, my lord.
Yes.
So that argument is only relevant for that particular period, my lord. Now 2012 onwards, we are in negative list regime, my lord.
Yes.
So negative
From
list
1-7-12.
1-6-12.
1-6-1-7.
1-6 second. From 1-6-2012.
1-6-12.
Yes, my lord.
Yes.
So even if the argument that it was not a life insurance business and the services rendered by them did not fall within the definition of life insurance business, my lord, in the positive list regime, but the remaining period of 5 years, my lord, they
Yes.
and the plea with regard to that was taken, my lord.
Yes.
And for that, they pointed out page 315, my lord.
66D.
66D, my lord.
Hmm.
The negative list shall comprise of the following services, namely services by government or local authority. And it was contended that they are a government, my lord. RGC is a government. So they will not fall with the definition of, or they are not taxable. Now, my lord, in my humble submission, and they cited the decision of Air Force Group Insurance Scheme, my lord, AFGIS. Now, my lord, the definition of government is provided under the Act itself, my lord.
You see, it comes on 66D1. Oh no, this is part 1 of
66D
No,
small a, my lord, it says that
yes.
the negative list shall comprise of the following services, namely services by a government or a local authority, excluding the following services to the extent they are covered elsewhere: services by the Department of Post and life insurance.
The should serve the government or local authority. Yes.
So they are saying, my lord, RGC is a government, and because it is a government, this is excluded under section, the definition of section 66D small a. And they cited the decision of Air Force Group Insurance Scheme, my lord. Now, Lord, so kindly come to page 309, my lord. The Act defines government, my lord.
Okay.
Page 309, my lord.
Yes.
Lord will see 26A, capital A.
Yeah.
Government means the departments of the central government, a state government, and its departments, and a union territory and its department, but shall not include any entity, whether created by statute or otherwise, the accounts of which are not required to be kept in accordance with Article 150 of the Constitution.
Hmm.
And they cited the decision, my lord. In my humble submission, the definition of term state under Article 12 and the definition of government are two distinct things, my lord. What I'll submit, my lord, like we say that all cows are animals, my lord, but all animals are not cows. So government will be a smaller thing, my lord, and state is a larger concept, my lord. Now that decision which they cited to Supreme Court, my lord, that's, if I may just take your lordship to Ravi Kokka's decision, my lord. What the Supreme Court held, my lord?
This is Article 12, yes.
Para 19, the concluding portion of the judgment. This is Ravi Kokkar versus Union of India.
Just pick up the page. One second. 19.
Para 19, my lord. Internal page 31.
Yes, consequent.
Consequent to the above discussion, abuse would be a state under Article 12.
Yes.
So, my lord, maybe Argis is a state, my lord, for the purpose of issuance of a writ under Article 12, my lord.
But not government. For
But it's not a government as defined under the Act, my lord. So, the plea that they are government, my lord, and so they are entirely exempted from payment of service tax, in my humble submission, is a fallacious argument, my lord.
1 second.
Constitution.
Yes.
Now, if I may take your lordship to Article 12 of the Constitution, my lord.
Now your argument is that it might be a state, but under the definition of the Act,
It is not a government.
Is not a government.
It's not a government.
Yes.
And that finds support in the definition of Article 12 itself, my lord. The Article 12 says, my lord, if I am just read, in this part, unless the context otherwise requires.
It's always good to read it again, yes. Yes.
In this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and legislature of each of the state and all local or other authorities. So, my lord, the state includes government, local authorities and other authorities, my lord.
Yes.
So that's why I said, my lord, all cows are animals, but all animals are not cows. The way animals may include cats and other animals also, my lord. So the definition of state includes, apart from government, local authorities and other authorities also. And local authorities and other authorities are not excluded from the definition, my lord. That's my submission with regard to the merit, my lord.
Yes.
So even if we accept that in the positive,
So at the base.
positive list,
at the base of the argument.
yes, my lord, as for the fourth contention, my lord.
Okay. For contention, of course, on merit.
Yes, my lord.
Yes.
And they even refer to the definition of government in General Clauses Act. Well, the General Clauses Act will apply where
There's no definition.
there is no definition in the particular statute, my lord.
Yes.
So, my lord, to sum up on point 4, my lord, that even if the contentions are accepted as far vis-a-vis positive list regime, my lord, that the other arguments with regard to definition of government in the negative list regime will not hold good, my lord.
Have you have any authority? But the state vis-a-vis government, because the common understanding will be that if you are government, then you naturally be state, even though they might be no.
Well, government is necessarily a state, my lord.
Of course.
But a state is not necessarily government. That's why I'm trying to submit, my lord. Because the definition of Article 12 itself says
that even that Air Force insurance, whatever is.
That only said that it is a state, my lord.
Right, but it's the same kind of functions. It's doing like the petitioners.
Well, right. That was a service matter, my lord. Ravi Kokkar decision is a service matter, my lord.
Okay.
They invoked writ jurisdiction, my lord, in a service matter.
Okay.
That's not a tax matter, my lord.
Yes.
Of course, one reference is made, my lord, in that if I may just refer to para 18, my lord. Judgment. Para 18, my lord, the Royal Court judgment. In addition to the discussion above, it is also seen that at one point of time, Afghis itself claimed to be government while claiming an exemption from service tax. Since it is under the control of Ministry of Defence, in effect, by opposing the challenge of the appellants, Afghis has recited from its own statement, we fail to understand an organization can be government for one purpose and not for the other. And then para 19 says that Afghis is a state, my lord. It doesn't say Afghis is a government, my lord.
Okay. Now, delay.
And in this regard, the findings of the, in the adjudication order was read yesterday, my lord, on the last day, that they are having a PAN card, they are registered as a trust, and the PAN card also indicates that it is a trust, my lord. So, for a trust to claim that it is a government, my lord, that is, in my humble submission, is too far-fetched.
Yes.
Well, third point with regard to bias, that
You're going from the back.
yes,
Yes, okay.
I think only 4 points, my lord. I'll go 4, 3, 2, 1.
Now the doctrine of bias.
Doctrine of bias.
Yes.
Now, my lord, in the tax jurisdiction or tax jurisprudence of India, my lord,
Yes.
this is a settled position that all departmental adjudication in all tax department, my lord, whether it is income tax, sales tax, VAT, service tax, my lord, the investigation is done by the department, my lord, and adjudicating authorities from the same department, my lord. We have not reached a level, or that is not an accepted view, my lord, except one Bombay High Court decision was cited, my lord, of 1988. Apart from that, it is a settled position, my lord, that all departmental adjudication is investigated by the department, my lord, and adjudicated by the department. That when it comes to next level, my lord, then there are independent tribunals, my lord.
Okay.
And then it comes
So
to
your submission at what level is happening? At the departmental level.
it is a departmental adjudication, my lord. Well, if that plea is accepted, my lord, that the entire tax law of this country, tax administration will change, my lord, has to change.
Yes.
Every tax department investigates the matter, my lord, and issues a so-cause notice and adjudicates. Next level, of course, when it goes to tribunal and it comes to High Court, my lord, under first appeal and second appeal and Supreme Court, then it goes to judiciary, my lord.
Yes.
But the second plea was taken with regard to local limits, the lordship recollect.
Yes.
That the circular, and therefore in fact put a challenge to the circular also, where local area, the Central Excise Act says, my lord, local area. I'll just take a lordship to that. Page 328.
328.
328.
Yes.
Well, this is the conformant appointment of Central Excise officers, my lord, as the officers of Service Tax Department.
Yes.
So, this circular, while empowering the central excise officers as officers, my lord, they've conferred power for the territory throughout the India, throughout the territory. Page 328, my lord.
Yes, you just surveyed the relevant line.
But it says, in exercise of the powers conferred by clause B, section 2 of the Central Excise Act, read with
Yes.
so and so, so and so, so and so, so and so,
Throughout the territory of India. Second.
throughout the territory of India. Second last line, my lord. Just above the table.
Very good. Yes.
And it was submitted, my lord, with reference to page 325. The rule 3 of the service tax rule says that the conferment of power or appointment of central excise officers with powers on us for a local limits only. So local limits cannot exceed to throughout the territory of India. Page 325.
One second. Let us try to understand. 325.
Yes, my lord.
Service tax rules, rule 3.
Rule 3, my lord.
Central Board of Excise may appoint such and so and so and so. Okay.
Within such local limits as may be assigned to them.
Yes. Okay.
So the contention is that central excise officers can be given or appointed for a local limits only.
Yes.
But this circular as page 328 is ultra-vires rule 3 because it confers power for the throughout the territory of India.
But I couldn't catch your submission. You're saying?
Well, 325 says
Yes, 25 says
that the board may appoint central excise officers for the purposes of Finance Act for service tax. Central excise officers can also exercise the powers under service tax laws, my lord, but only for a local limit.
Yes.
Now, in exercise of this power, my lord, the page 328 has been issued because there is a reference to rule 3 of the central excise rules also. Sorry, my lord, 3 of the service tax rules 1994.
Yes.
So, in exercise of Rule 3 of the Service Tax Act, Service Tax Rules, my lord, a circular has been issued which confers power on officers throughout the territory of India, which is not in consonance with Rule 3 of the Service Tax Rules, my lord.
Which is not in
conformity with Rule 3 of the Service Tax Rules.
Yes.
Service Tax Rules talks about local limits, my lord. And it was submitted local limit cannot exceed more than a state. It has to be confined to local area only. Cannot be throughout the territory of India.
Yes.
Now this aspect, my lord, they themselves have annexed Madras High Court decision, my lord, page 719. Reddington's case.
The petition itself.
Yes, my lord.
Page
719.
Yes.
Page 177 and 178 was read, my lord.
Page?
What? At page 755.
Para, I mean.
Page 755, my lord. Para 177 and 178.
Thus officers.
Thus, officers of Director General of Central Excise Intelligence are Central Excise Officers for the purpose of Section 2B of the Central Excise Act 1944. They are empowered to exercise powers pan-India under notification number so-and-so dated June 26, 2001. Therefore, the other ground to challenge to the improved notification dated September 16, 2014, that pan-India powers have been vested with the officers from the Directorate of Central Excise Intelligence and contrary to the restriction under Rule 3 of the Service Tax Rule also fails. So, my lord, the Madras High Court has taken a view, my lord. And in my humble submission, this is the correct view. There is no reason to take a different view, my lord, on this.
So they cannot.
Of course, this is a single bench's order, my lord. But the same challenge was put there also, my lord, and that has been rejected, my lord.
Where?
In the Madras High Court, same challenge was taken, that local limits and throughout the territory of India, that was rejected, my lord.
See para 182. That page.
192.
7 years.
192.
For the same judgment.
Para 192. Yes, my lord. They have upheld the view, my lord, that they can exercise powers of pan-India, my lord, in view of the
mentioned about under Rule 3.
Yes,
the board company other officers excise vulnerable. How the would not mean that officers of so and so, the ordinary so and so, follow India excise, cannot exercise power pan India.
Yes, my lord.
So that is the view.
So that is the view taken by Madras High Court, my lord, denying their contention, my lord.
Yes.
So that was the second argument taken by them, my lord, and the first argument, and for me is the last argument, my lord, that page 318, my lord. That adjudication order could not have been passed after 8.5 years, my lord. Delay.
Now, so is here, then you finish the doctrine of, okay. But then you're mixing up two issues then, GCI and this doctrine of bias. If you have to do the other, you have to address other point first before you come to delay.
But 4 points, the fourth point was on merits, my lord. Third point was with regard to bias, my lord. That
Yes.
the departmental
Third is on bias, yes.
departmental authorities themselves are investigating, and they are
But that you addressed,
adjudicating.
okay.
They have addressed, my lord. But that is the system, my lord, for this country. Second was with regard to local limits, my lord, primarily.
Now to last point.
The last point, my lord.
Yes.
Now, reference was made to page 319, my lord. Section 73, 4B, my lord, of the Finance Act.
Within 6 months.
Within 6 months, this case falls in clause B, my lord, within 1 year.
Yes.
Now it says, my lord, if I may just read from the section, the Central Excise Officer shall determine the amount of service tax under subsection 2, clause B, my lord, within 1 year from the date of notice, where it is possible to do so, in respect of cases falling under proviso to so and so. So we are not concerned with that, my lord. The timeline prescribed is within 1 year from the date of notice, where it is possible to do so, my lord.
So it's not mandatory.
So it is our case, my lord, that it is not mandatory in that sense, my lord. It leaves leeway, my lord. Where it is possible to do so, we are required to do that. If it's not possible to do so, we can exceed that time limit, my lord.
Yes.
Now, in this regard, my lord, Lordship has noted the so-called notice was issued on 5/10/2016, my lord.
Which year or which date?
5/10/2016. Adjudication order was passed on 12/3/25.
Was on 5/10/2016.
5/10/2016, my lord, and adjudication order is of 12th March 25.
Show cause was on 5/10 and order is on
12/3/25.
12/3/25. Yes.
Now, what happened during this period, my lord? If I'm just explain that, my lord, that they are contributing to this delay, my lord. And for that, I'll take your lordship to case 604, my lord. They are submitting representation to the Ministry of Home Affairs, my lord. This is dated 7/11/2017. A proposal for inclusion of name of Assam Rifle Group Insurance Scheme into the service tax exemption list. They are writing to the government, my lord, to exempt them from service tax.
Yes.
Now there is a series of letters, my lord. The page 608 is another letter, 21st February 2018. (612) is another letter, my lord. (613) is also another letter. And finally 614, my lord. This is dated June 25, my lord. I think it is 6/6/25, my lord.
It is 6/12.
Page 614, my lord.
Yes.
So this is dated 6th June 25, my lord. And finally, the request was rejected. The representations were rejected, my lord. Para 2, if I may just refer. Subject retrospective exemption of service tax imposed on Assam Rifle Group Insurance Scheme. Para 2, my lord. In this regard, I am directed to state that the matter has been duly examined and your request for retrospective exemption of service tax payable by RGs has not been approved by the competent authority. This office letter number so and so is enclosed. So this came on 6th of June 2025, my lord. But this remains a fact, my lord. The department did not wait for this order. The adjudication order came before even this letter, my lord. Adjudication order has come on 12th of March 25 itself.
Yes.
So, my lord, our submission is that.
How do you explain 16 to 25? That's 9 years. It has to be a very convincing explanation.
Well, the only explanation we have stated in the affidavit, my lord, is that it was a complex case.
All cases are complex.
That's true. It was a complex case and interdepartmental some investigation.
That's the same excuse taken by all central government departments, department desk to desk. inter-department, intra-department.
So, my lord, this is where we stand, my lord, the department.
There's no other.
There is, because only thing, my lord, it has been pointed out, my lord, similar orders.
But then the thing is that anyway, I'll not.
Similar orders have been passed by various high courts, my lord, that 1 year period cannot be extended to some uncertain length, my lord. 1 year, as far as it may be possible, can be extended only to maybe to a reasonable, and that also for a justifiable reason.
By 7 years.
It cannot be extended by 8.5. Those are the reasons, but that is also again pending. Of course, the customs matter because similar provision.
Do you have any authorities? Because your explanation does not really.
But on delay, my lord, that is only explanation given in the affidavit. If I may just point out the affidavit, my lord, two paragraphs only.
Yes.
Para 35, my lord. Page 17.
Yes.
That with regard to the statement so and so, the deponent states that the interpretation sought to be placed on section 73(4)(b) of the Finance Act is selective and contrary to the statutory framework. The provision clearly uses the expression where it is possible to do so, which acknowledges that 1 year timeline is directly not mandatory and is subject to administrative contingencies, complexities of the case, and availability of complete information from the taxpayer. In the instant case, the assessment could not be completed earlier due to the petitioner's own failure to furnish full and accurate details, thereby prolonging the inquiry. Further, the petitioner opposed Department of Revenue seeking retrospective exemption from levy of service tax, which was duly rejected by DOR, Department of Revenue, Ministry of Finance in March 2025. The contention that the matter was kept in cold storage is emphatically denied. The record demonstrates continuous processing and examination necessitated by the intricate nature of transactions, incomplete disclosure by the petitioner, and the requirement of verification of the multiple sources. At no point of time were proceedings kept pending arbitrarily at the whim and fancies of the adjudicating authority. The extended period under the proviso to section 733(1) was correctly invoked. That's not relevant, my lord. And further in para 7 also at page 5, my lord, you said the same thing, more or less. Para 7 at page 5.
Repeated what you said there.
More or less.
What will send the rejoinder?
Page 7 all. They refer to IDFC First Bank decision which they placed yesterday.
Long completed before show cause. So this whole plea that they had to carry out detailed investigation interdepartmental is not at all relevant. Because after investigation, show cause comes. So from the show cause, there has been 8.5, not prior to the show cause.
Yes.
Well, that's all I had to submit.
Yes, any reply submissions, Mr. Gould?
We'd like to make a submission on 19th, if convenient from 2, my lord. 19th. I'll come physically.
It's a Tuesday, my lord.
Okay.
I'm so obliged.
This is the matter for the hearing on 19th, yes. Replies by the petitioner. You know authorities, Dr. Marisa.
I'll try to place one.
You place authorities also. This is... Yes.
Any mention?
Please, Your Lordship, I beg to mention item number 31.
Who's the other side? No one there? You informed them?
Yes, sir.
You informed them?
Yes, Your Lordship.
Who's the other side?
31.
PT Sangma.
Yes.
Not aware is your case.
Yes,
Not aware.
Your Lordship,
that's why.
Your Lordship, we are yet to receive instructions, Your Lordship.
No. What instructions?
This is regarding the pension, this is Paula, because
What instructions?
From the JCDC, Your Lordship.
What's the last order say? Do you know the last order of the court? It's not with you.
No, sir. No, Your Lordship.
I got to go 31. See, just advice for juniors now, whatever is before you mention when the matter is taken up, always have the last order of the court with you.
Yes, Your Lordship.
It's always beneficial. Yes, no, we'll call it out. Yes. You tell your senior. Yes.
Please, Your Lordship. Lordship, I beg to mention item number 32.
Number?
32.
I'm for responding number 6 and 7.
Who's for the state? No one.
32? 32, yes. I'm for the state, my lord.
You're not there for the state.
Akrizaman Pradhani, yes, my lord.
Who?
Akrizaman Pradhani, yes.
Who's
For the
there
state.
for the state?
Yes, ma'am.
No objection.
No, ma'am.
32.
32. My lord, similar prayer for item 40 and 41.
No objections, my lord.
40
and 41.
41? No objection. Hasina Khatun, yes. Yes.
Obligation.
Daily list item number 1.
Please, Your Lordship, I'm here on behalf of
Yes.
Bearing on behalf of Mr. Day, Your Lordship, I pray for 2 weeks' time, Your Lordship, to file affidavit.
I filed a miscase, Your Lordship, for striking out respondent number 5.
Miscase. Oh, miscase 141. Yes, sir. Number 5 is whom?
The accountant, Your Lordship.
Attorney General.
No, just the accountant of KHDC.
Yes, but miscase 141. And so this application is for striking off the respondent number 5 from the array of the parties in the main petition. The same was objected to by the counsel for the respondents. Accordingly, that the respondent number 5, that is, where is the petition? Main petition. Main petition. That is the accountant Garzel's counsel who was struck off from the area parties. This case allowed registry to win the corrections in the main cost title. Yes, what do you want in the main case?
2 weeks' time, Your Lordship, to file for affidavit.
The state respondent will not be filing any affidavit, Lordship.
Yes, what's your name?
J. Suchang, Your Lordship.
Your name?
J. Suchang.
K. Suchang.
J.
Speak up. Speak up. Yes, Mr. K. Suchang.
J. Your Lordship.
J. Suchang. Why the SD? On 3 and 4 praise was up further time to file affidavit. It's after 2 weeks.
Supplementary 1.
Mips Lordship. Lordship, this is the second round of litigation. Earlier order, Lordship, in the order dated 09/09/2024, this court has directed for consideration of for regularization. That order dated is 13, page 34, last para, Lordship. Page 34, the para 4, my lord. Just.
Yes.
It is stated accordingly in view of the submission, it is directed that as the proposal for regularization.
What happened after that?
Your Lordship, this gentleman, the storekeeper, Your Lordship, has been regularized by an order dated 2025.
What about the pension of his wife?
2025, Your Lordship. Now the matter is under process, Your Lordship, but we need to seek some instructions as to the present status.
Issue notice, returnable in 2 weeks. Next time, MS Yangi B. Leonard EAG, with so and so present. On behalf of all the respondents, no further notice required. It is next paragraph, Mr. P.T. Samar and counsel submit the second round litigation.
Yes, this is second round.
We are praying for fund pension to be granted to the petitioner, who stated to be the legal wife of one late Emmanuel Arrange.
Yes, Your Lordship.
Who had served as
a storekeeper
in the office of assistant agricultural engineer. Assistant agricultural engineer bracket mechanical East Garhilgram Nagar. Stop. MS T. Yangi AG submits that pursuant to the earlier litigation, the services of the deceased employees has been regularized and the matters in the process.
In the year 2025, Your Lordship.
In the year 2025, she prays funds allowed. She prays that she allowed to come up with instructions the next date.
Your Lordship, I'm appearing on behalf of 1, 2, 3, and 5.
1, 2,
4.
3, 4, Your Lordship. Okay, 3 and 4 is Mr. K. Present except 4. Yes, it is up to 2 weeks.
Much less, Lordship.
2.
Yes. Is that late Mr. Siddiqui's matter?
Yes, sir.
I can't take it up just before any other bench without.
3.
Yes.
Okay.
Without me, just yes. Yes. Consent's been received.
Consent received.
I usual order, yes. Disposed. Yes.
4.
Supplementary.
Oh yes.
His Lordship, appearing for instructed to appear where so respondent number that is one respondent.
You have any objection for transfer?
I have objecting, Your Lordship.
Then why didn't appear all this time after
no,
the
no,
notice?
actually some counsel was appearing. Actually, only today I was.
Only after the order was passed yesterday, that is fixing it again today, that you appeared.
Yes,
yes, Mr. P.T. Samat entered the parents today on behalf of the sole respondent. So he prays for 1 week's time to obtain instruction.
Lordship.
Yes.
Much better.
Otherwise, normally if the wife resides in Tura, I'll go to Tura.
Convenience of the wife.
Yeah. Much better.
Daily list item number 4. Sorry, item number 2.
Your Lordship, Mr. Day.
1 second. Let the file come. Yes.
Your Lordship, Mr. Day cannot appear today. His mother is admitted in the hospital, Your Lordship.
Where's the petitioner? Mr. P.T. Sangma is here just now.
Yes, Lordship. Sorry, Lordship. Lordship, this is.
You heard the prayer. It can't be done today because the Housing Council's mother, as it's been submitted that the Housing Council was one number 4 has some personal difficulty. This matter up to 1 week after. Yes.
Much less, Lordship.
3.
3 same. 2 entries.
4.
This together with. Yes, Mr. Judge.
My lord, this is a non-compliance of the order, my lord. Yesterday they filed a affidavit, my lord, which even cannot be taken on board, my lord.
Why?
My lord, can come to page 2, para 1.
Yes. Yes.
My lord, I have received a copy of the contempt petition.
Yes.
Captain such and such is not a party to the contempt proceeding, my lord.
Yes, Dr. Mojika, why is this contempt personal?
In person, my lord.
Just to bring on, because
it cannot be taken on board, my lord.
Is it your case that it's all been complied with?
It's been complied with, my lord.
No, my lord. It is not the,
because the contemnants are Union Home Secretary and DG, my lord. Just to bring on record, my lord.
Due to these officers, my lord, the DG is unaware of the facts, my lord. The old petitioner, my lord, where he will go after getting after 1 year, my lord, a medical board was constituted, whereas the direction was for the compliance within 1 month, my lord.
Who's Govind Mohan?
Govind Mohan is the secretary.
Union Home Secretary.
He's still the same one?
Yes.
Well, he has to sign all the affidavits, my lord.
No, he won't sign affidavit, but it's... Now, where have you said you complied with the order?
Nothing.
Where? In your affidavit?
But if I just read, my lord. Para 2, my lord. I'll just read. In the contempt petition has been filed for non-compliance of the order dated 6/2/25 passed by this order, which respondents were directed to complete the requirements and formalities of assessment of disability of the petitioner within a period of 1 month, and thereafter to complete the entire exercise of determination of entitlement of the petitioner's disability pension within a period of 2 months thereafter. Pursuant to this, the respondents have initiated the process for conducting the fresh review medical board, and the petitioner and the same was conducted at Assam Rifle Multi-Specialty Hospital, High Court on 18/3/2006 for assessment of the attributable and percentage of the disability of the petitioner. That the petitioner was physically and medically examined by a duly constituted medical board consisting of expert doctors, and the medical boards have assessed the percentage of the disability of the petitioner as 13.114%. That, however,
how old are you now?
My lord, approximately 80 years, my lord.
But he was discharged 48 years back, my lord.
My lord, irrespective, pension is a continuity.
No, it's not a still continuing wrong or continuing right. But things that 48 years ago, then why didn't you bring the other medical documents? Don't have any more.
My lord, I don't have. At their behest, I have assessed my disability in the civil. They did not recognize, my lord. That's why I subjected to the writ proceeding, my lord.
Very peculiar.
And after 1 year, my lord, after 1 year,
they know that they conducted it on 18/3/2026.
Only on
1 year.
After 1 year, my lord.
He participated in that, my lord. Now, at this moment, he cannot say. He should have refused to do that, my lord.
Where's the certificate of 13 point something %? But it's judgment of the Uttarakhand High Court, no?
My lord, even Uttarakhand High Court, even, my lord, their own notification, even 1% is also they are liable to be given a disability pension, my lord.
To service,
United fracture. That's their disability. Lifelong treatment, yes. What other documents do you need?
Whether it was caused due
to your own report.
Whether it was caused
the fact that you did it after a year. The thing is that your certified assessment disability is based on the all medical condition. Where's the other communications we said that you needed further medical records of the petitioner?
Nothing, my lord. Nothing on that.
Then we'll issue notice of contempt.
Well, kindly see.
She has to.
Assessment was done. 13.114% disability has been determined, my lord. Now he is out from service for past 50 years, my lord. He came to this honorable court after 48 years, my lord. He doesn't have any document. We also maintain document only for 20 years, my lord.
He was discharged in February 1978.
Yes, my lord.
78.
76, my lord.
Discharged from service.
My lord.
No, he was posted in 3rd Assam Rifles on 75 years. Give him something. Give him a consolidated amount. Else will drop contempt.
Even in this affidavit, my lord, there is not a whisper that thereafter what steps they have taken. My lord, nothing. That's
They are
why
putting the onus on you. This thing that you asked for.
that should be in the writ proceeding, my lord.
This statement was recorded on 18 March. Yes, sir.
My lord, after 1 year, my lord.
Page 5, serial number 2. In respect to which decision the medical board will express its view as to whether it is attributable to service during peace or under field service conditions cannot be ascertained.
No, now you can take a statement. While he's patrolling, he slipped and fractured his left radius, and plaster of Paris was applied. How old now? He's 80 years old. How do you remember?
He came to court after 48 years.
My lord, these are the things which is to be they have already agitated, my lord, in the writ proceeding. If they were so aggrieved, my lord, they could have filed an appeal, my lord.
No, they've done what they've done is they've done the review medical board
after 1 year.
Then they should have given a final finding on it.
My lord.
Yes. We can't pass orders, but then you just take instructions. Otherwise, an affidavit is filed in behalf of the respondents. However, strong exception has been taken to the same by another counsel, the petitioner, who has submitted that the person who has sworn affidavit is not a party respondent in the instant case. Stop. Further, it is submitted that though the order of this court had been passed on 06/02/2025 to complete the assessment of disability within a period of 1 month, the respondents who submits had conducted the same only on 18/3/2026, where the percentage of disability of the petitioner was assessed at 13.114%. Stop. Dr. El Musica Leonard DTI, paying for response, submits that the affidavit has been filed to bring on record the developments that have taken place after the order of this court, and that as per the affidavit, the previous medical documents, records of petition are not available to enable the respondents to ascertain as to whether the injury, as stated, occurred in the line of duty. Stop. This court, having noted the submission of the materials, however, is constrained to observe that though the order was passed in 6/2/2025, the review medical board was constituted only a year thereafter. So, though the petitioner might have been discharged as many as 48 years ago, or orders of this court have to be complied with in letter and spirit, yes, notwithstanding any other extenuating circumstances. Yes, just after you file your thing, we'll take it up. Otherwise, what this court observed, you kindly list after 2 weeks you file rejoinder.
But only one more thing, my lord. In the writ petition, there are several parties, my lord. Lord, so kindly see page 11, my lord. The order in the original writ petition. Yes, my lord, page 11.
Yes.
Now there are 4 respondents, my lord. If you can implead 3 and 4 also, it will be easier for us to file affidavit also. Now he impleads a union home secretary and DG.
Difficult also.
My lord, that's.
You can implead these 2 also.
My lord, my lord's order 4th November 2025.
This, yes.
4th November 2025, my Lord's order.
4th November, where? This is a contempt matter?
In contempt matter. Where is my Lord has said that the compliance report should be.
Doesn't matter. This is the things gone ahead of that. It's not a question of even granting it, Dr. Moses. It's a question of just complying with the court's order, whereby you complete entire assessment. And if he's entitled, then you compute the.
He is disabled with 13.14%, my Lord.
Irrespective of that,
now that has to be attributed to service. I'll have a step. I'll file another affidavit.
I'll file it. Yes. Subject to after the affidavit is.
And if you want more effective relief, I think better you include more parties. Yes.
5.
Otherwise, if you ask once the appearance of the home secretary,
my Lord,
will appeal tomorrow.
Only DG will suffice, my Lord, not the.
Yes.
5.
His Lordship, they are filing in this case, Your Lordship. I may be allowed to file the objection. They want to implead. They want to implead JHDC as a party.
To implead.
GHDC, District Council. My Lord, because there were certain.
No, not you. I'm saying he. You're objecting to impleadment.
Yes, Lordship.
Why?
Because the money, the land was purchased by the MECA department. GHD has nothing to. There is no role by the GHDC.
Why don't you implead them?
It's not required. Money is paid by the purchase and taken by between the NOCMA and the this one only MECA department. GHD has DC. They have nothing to do.
No, see, you read the application. You read paragraph 4. We'll implead them, Miss. This case. There's an application by the respondent number.
I'm respondent number 1, my Lord.
Number 1 as applicant for impleading the GHDC through the chief executive member. You don't implead the chief executive member. Actually, it's a secretary legislative committee. You correct the first title.
Yes, my Lord. I'm for respondent number 2 and 3, my Lord. 2 and 3.
See who you're trying to implead now.
My Lord, I'm trying to implead the GHDC.
No, see what you've written in your course title.
My Lord, I have corrected my cost title, my Lord. I'm the managing director.
Your course, who you impleading?
I'm impleading
You want to
GHDC.
implead the chief executive member?
My Lord.
Okay, you want to implead the chief executive member. What are you impleading this? Why should we take classes here? I can't understand.
Oh, I'll correct that,
my Lord. Even in course results, they are filing under section 151 of CPC.
I'll correct that, my Lord.
All those things, they're defective. This cannot be. And they have not specifically mentioned.
My Lord.
Yes, due to certain defects, MS case 123 to 26 of 2026 in WC 168, MS OI Bank, somebody due to certain defects, we have to withdraw the instant application and to file a fresh. Praise allowed.
This is the second time they have withdrawn also.
There's some.
Earlier also because of the defect.
Apply your mind.
Yes, my Lord.
Yes.
Much less Lordship.
File rejoinder, Ms. Sinkram.
They have not filed.
With regard to respondents number 1 to 5, I'll be filing in the course of the day, Lordship. But I'm
6. And therefore 6.
Yes. You file affidavit.
He's filed on the last date.
You file for rejoinder, no.
I'll pray for time for affidavit of respondent number 6.
With regard to the affidavit filed by respondent 1 to 5, the rejoinder will be filed the course of the day. However, with regard to affidavit filed by number 6, the prays for further 2 weeks' time for rejoinder. Any interim orders? No.
7.
I'm paying some more time to file an affidavit, Lordship.
What's the matter about?
This matter pertains to dismissal from service, Lordship.
Working which department?
Police department, Lordship.
Okay, I prayed for the 2 weeks' time allowed.
8.
Master Lordship.
8.
Please, Your Lordship, I seek 2 weeks' time to file my rejoinder, Your Lordship, to the affidavit of respondents number 6 and 7.
Where's PS number?
I'm here, Your Lordship.
What instructions have you got?
Lordship, we're not filing with a performer respondent here.
Is Mr. LCM praised for? Not further.
2 weeks' time,
Trying to file rejoinder to the affidavit filed by response 6 and 7. MSPS number within 9 submits that no effort will be forthcoming from said respondents.
Interim orders are there, Your Lordship.
Interim orders need to continue.
Deeply obliged.
9.
Yes, Mr.
Your Lordship, I have filed. I don't have anything regarding that objection. But
why are you filing on?
They filed a miscase instead, Your Lordship.
I have filed a miscellaneous to amendment of the course title, Your Lordship. Kindly allow us to.
I may be allowed to file my objection. They have filed a miscase to amend the course title of the.
Under Rule 6.
Where's the miscase? Where's the miscase?
Under Order 6 of Rule 2013, Your Lordship.
Yes.
I may be allowed to file my objection, Your Lordship.
Why objection?
Lordship, this miscase is an afterthought after I filed my objection, Your Lordship.
You'll never end then. Then you withdraw and file afresh then if you're objecting. No objection will serve no purpose. You concede, what is the point?
Your Lordship, previously they have filed only under 226, Your Lordship. So now, after filing my objections, they have sought for amendment of the clause title.
That is what, sir?
Are we allowed to file a short reply, Your Lordship? Dismiss me.
What purpose will the reply serve, Mr. Prosecutor?
Your Lordship, if this amendment is allowed, Your Lordship, then will change the entire nature of the repetition.
It will?
Yes, Your Lordship.
What is the dispute about?
This is between wife and husband. Yeah.
Mrs. Application number 132-2026. This is an application for amendment of the course title amended petition. Stop. The amendment sought for is even para 2 of the instance misapplication. Stop. Though the prayer is innocuous, there's a positive praise that you without a part of the but in 1 week we'll dispose after that. I can't shut you down, so you file objection. Yes.
Highly obliged.
10.
Well, this is a contempt petition, Lordship.
We have practically complied with the order of the Sonbrook Court, Your Lordship.
Yeah. Lordship, that is not the factual position, Lordship.
Let us see. If his compliance is willful disobedience, Lordship, or is compliance?
In fact, Your Lordship has directed that the suspension, which was beyond 90 days without review, that is illegal. That has been withdrawn, Your Lordship. But Your Lordship's order was passed on 3/12/2025. On 31/12/2025, he actually retired, Your Lordship. Therefore, the restatement cannot be done.
Oh, he retired?
Yes, yes. 31/12 itself is
Lordship has in the order itself mentioned that because of the fact that the petitioner is retiring on 31st December 2025, respondent university will act expeditiously, Lordship. They had the entire month of January to act. They did not act. They did not reinstate the petitioner. January, February, March, they didn't act.
He retired in March?
No, he retired in 31st of December.
December. And we filed contempt. We filed contempt in the month of April. Now they have issued this order wherein they have mentioned that
April itself we have issued.
They have issued that the suspension has been revoked. But this is a very ambiguous order, my lord.
No, but
Lordship will kindly see.
They'll have to reinstate me.
Where's the order of revocation of suspension?
Lordship's
affidavit. Have you filed affidavit?
No, affidavit was not filed since this
No,
order
no,
was.
where's the revocation order?
This order, Your Lordship, has been issued.
That is the only order you passed.
Yes.
Lordship, Lordship, this is the only order. They have
Revoking the suspension.
revoking the. What about reinstatement, Lordship? My lord's order is very clear. Lordship, in the petition, page number 9, Lordship. Operating part will be the last page number 12, Lordship. Paragraph 6 is the operating part, Lordship. In the instant case, it is not disputed no review has been done till date. As such, by operation of law, the petitioner is entitled to be reinstated into service as the suspension can no longer be held to be valid. Lordship, here, the direction of reinstatement is very clear, Lordship. Here they passed a very ambiguous order. Suspension has been revoked, Lordship. What does that mean, Lordship?
So
what will happen to my reinstatement?
He will be deemed to have been in
Lordship,
service after that.
Lordship, if I am not reinstated, that
File an affidavit.
Lordship, I'll file here.
Yes,
Lordship, another.
Mr. Manan.
Lordship, I also want to highlight one fact, Lordship. The new development has taken place. Lordship, subsequent to filing of contempt case, Lordship, contempt petition, Lordship, what they have done, Lordship, what the university has done is that they have filed show cause, Lordship. They issued a show cause after my retirement, Lordship, just to circumvent the order of this honorable court, Lordship.
No. This court said that does not preclude them from taking further action.
Lordship,
the only thing, why you succeeded in petition, because it's on a technicality.
Lordship.
Technicality was that if they didn't do a review after 90 days,
Lordship,
then the suspension becomes invalid.
But they have plenty of time.
If they done a review and sat, then the suspension could have continued.
Lordship,
we don't looking at the merits of the case at all. The thing is that now that is even this order, which the court disposed of the order. He said that by operation of law, he is to be reinstated.
Lordship,
but does not preclude them from taking further action.
No, Lordship. But what they have done, Lordship, their conduct itself shows that there is some kind of malafide, Lordship. Because I have retired 4 months after my retirement, Lordship. They have issued this so-called and they have written why the pensionary benefits cannot be withheld against you, Lordship. Now, if Lordship order is very clear, once I am reinstated, Lordship, my pensionary benefits will be the conjugal benefits, Lordship. That will be the conjugal.
No, that will not be consequential. It will be subject to other circumstances.
The provisional pension is there as per the CCS pension rules, Lordship. Lordship, I have to be paid, Lordship, so, till the outcome of the.
Paid anything now?
No, nothing, Lordship.
You have to bring a new petition.
That,
yes, Mr. Manan today has produced a communication dated 27 April 2026, which submits as in full compliance of the orders of this court dated 9th December 2025.
3rd
December, Your Lordship's order.
3rd December 2025. Tom. Ms. S. Pandey submits that the action of the reinstatement petitioner was belated, that too after he had already superannuated on
31st December 2025.
December 2025. So he praised for permitted to file an objection to the. Oh no, sorry. Just stop. Mr. Manan praised him to file an affidavit to bring in report. He said order has to come in report plus any other fact that want to be placed.
Yes, sir. I'll place that.
The other thing that we can't
because that will be on a writ petition.
You file it after 2 weeks.
Yes.
11.
Applies to.
We'll file last.
Come for hearing. Pursuant to the last order, I think there were some instructions to be obtained by the union.
Yes. You not here, Dr. Mozika.
Yes, ma'am.
But it appears that even creation of a supernumerary seat was not necessary. You also allotted your PG seats. So how are we going to take the matter forward now?
Well, here what happened, because of a shortage of faculty, my lord,
No, that was never the case put up when the matter proceeded earlier. It's just that we have to create an additional seat.
Because that was not an issue at that
have come out now that you are paying for. Huh?
That's Nehu, my lord.
What about the other?
My learned senior is appearing for
the remaining.
Okay.
1 to 4 and 6 to 9.
Except number 10.
You've seen the order dated 29.
Yes, ma'am.
Then what do you have to say?
No, my lord, that was not an issue in earlier round, my lord. The earlier round was only pertaining to he reported late, my lord.
No, votable. Whether you could create another seat. That's all. Because he admitted the other person who came was next in line. But then it transpires that you have a lot of seats.
Now, supernumerary will not come into picture, my lord. I'll play some reason that midterm admissions are prohibited, my lord. That's one aspect. A second aspect is, my lord, there cannot even be telescoping, my lord. He cannot even be admitted in the next.
So now, forget it, my lord. But consider him for the next with the same score, neat score.
Correct. But same neat score.
Instructions.
My lord, I have decisions on that, my lord. This will deprive other students, my lord. He has to reappear for NEET exam, my lord.
It's not unfair.
But in fact, I have judgments to the contrary, which says in the next year they can be accommodated.
It can fix for hearing, my lord. My lord, the judgment that is placed, my lord, where the authorities were at fault, my lord. Here the student himself is at fault, my lord.
I'll distinguish that, my lord. There also made certain observations in the last order itself. But then kindly have this next week, my lord.
Done musical edit DHI correspondence 1, 4, 6 and 9 submits that though the question of creation of supernumerary seat at this stage is no longer feasible in view of the fact that the course has since proceeded.
One semester is almost over,
and one semester is already over.
Almost over. Almost over.
Stop. Next one. Mr. SN, however, contended that the petitioner can be accommodated in the next session.
As well as this, I'll insist on both. Lordships will decide.
This year's supernumerary is out of question now, my lord. Lordships is possible.
Yes, notwithstanding the surrounding facts. Yes. This is a matter for hearing after 1 week. Yes,
Lordship. Highly obliged.
12.
They would same score, they can't.
Cannot.
I think there are cases where.
Yes, my lord. In fact, in that Shireen Dakhar's case, Lordships had referred to the Supreme Court judgment in Arya, Shraddha Arya. That's although it was in the question of MBBS seats, but the same principle will apply to all these admissions.
Where the authorities are at fault, my lord. Here, if the petitioner is at fault,
I'll try to satisfy, my lord. I'll try to satisfy. Obliged.
May it please, Lordship. As per the last order, Lordship, we have taken steps, Lordship.
Anyone's appearing?
Lordship.
Not received.
If it's not received, we'll file a status affidavit.
Notice yet to be served when they respond 1 and 2. Next, Mr. Dakhar pays allowed to obtain
status report
and file affidavit necessary. Just after?
After 2 weeks.
2 weeks, yes.
13.
Obliged.
Please, Lordship. Lordship, on the last occasion, my lord, we had accepted notice on behalf of all the 3 respondents, but my learned friend is entering appearance for number 3 separately, Lordship.
Respondent 3, Lordship. Who's that one number 3?
He's the secretary.
Executive Committee?
Lordship.
GCDC?
Lordship.
We file a power today.
1 second.
So we are only appearing for respondent 1 and 2, my lord, who are the CEM and the deputy CEM.
Ricardo Marak, you're appearing for him? Yes.
And I'm praying for 2 weeks to file an affidavit.
Then counsel submitted that they will henceforth be appearing only for respondents number 1 and 2. As an alternate counsel, namely Mr. Paryat, who's present in court today, has been engaged for number 3. This is matter after 1 week for affidavit.
2 weeks. Lordship, small submission. Due to non-compliance of this order, the functioning of the JCT's judicial court is very much affected. Since from February till date, there is no judge of this one.
Yes, for affidavit.
14.
Much obliged, Lordship.
May please, Your Lordship, I would require further time to file affidavit, Your Lordship. This will be my second time asking.
This is bank freezing matter?
Yes, my lord. It's not bank freezing, my lord. This is unauthorized.
Unauthorized.
Fraud. Yes, unauthorized.
Which resulted in freezing
withdrawal.
the account.
Withdrawal.
Unauthorized withdrawal.
Where's status report?
My lord, I'm appearing of Mr. H. Kamanam. He's in his post, my lord.
You appeared last time also 1, 2, 3.
Lordship.
What are you saying? Last time Mr. Jendran Jha, you submit the status report received. After will be filed within 2 weeks. Where's the affidavit? No, why are you saying Karwan Lang? You appeared last time.
No,
don't make the submission.
On his behalf, my lord.
Achu, who appeared last time? J. Ranja appeared 26-3. You again appeared 18-4. Before that, I don't see my Karan's name. Before that, MSS Lalu. You can't just pass the buck around. Yes, Lalu. Zedi Nongkandri, never seen Karan's name once also. Only 9/2/2026 at a time of motion.
All right, 2 days time, my lord, may be granted.
2 days time won't solve anything, yes.
My lord, you should give them time because I cannot do anything about the status report.
At least 2 weeks for us for affidavit, Your Lordship.
As much fun for?
For respondent number 4 and 5.
4 and 5. Meji Anja for 1 and 2. 1, 2, 3.
2, 3.
So for 1 week's time to file affidavits. This court notes that on the last date, that is 18/4/2026, the government advocate, that is with present today, had submitted that status report had been received and that affidavit will be filed within 2 weeks. However, today time has been sought again. Yes, the court expresses its pleasure with this conduct of the government advocates on the panel of Meghalaya with regard to shifting the responsibility to other councillors. Yes.
15.
Just after 1 week. You appear for 3/4 years. Don't make a submission. Yes.
In this case, we have filed an affidavit, Your Lordship.
So it can be fixed for hearing next time.
Yes.
It can be fixed for hearing next.
You don't want to file rejoinder?
I won't file rejoinder.
You want to file rejoinder?
No, I won't.
No. Mr. M. Sama submit that no rejoinder will be necessary. The affidavit files its respondents will list the matter for hearing.
Highly obliged.
Obliged, Your Lordship.
16, we are awaiting additional instructions. In the meantime, my lord, with regard to the advertisement, another PIL has been filed, my lord, which is pending before the Honorable Division Bench.
1 second.
We are aggrieved.
Which matter is this one?
Lordship, we are.
Anwar Hussain?
Yes, my lord.
We are primarily aggrieved with the extension of the Special Managing Committee.
Number 6. You appear for number 6.
Affidavits are awaited here.
Have you filed affidavit?
My lord, I am awaiting some more additional instructions.
Appearing for respondent.
You file additional affidavit or something?
On an advertisement.
In the meantime, my lord, they had filed a miscase regarding an advertisement which was floated. Now, this Honorable Court has
Not
already
miscase,
observed.
affidavit. It's an additional affidavit, not a miscase.
So, however, my lord, this Honorable Court has already issued an order saying that the outcome of the selection process will depend on the outcome of the writ petition, my lord. In the meantime, they have filed another PIL, my lord, on the same issue.
PIL?
Yes, my lord.
How do you file a PIL in service
Exactly,
matter?
my lord.
They file a PIL in a service matter?
In the PIL, all we are saying
Challenging
is
the advertisement.
nothing to do with this particular petition. We are saying that roster system should be implemented in all the schools while appointing the teachers. And in this matter,
So
Lordship,
yes, you are bringing into the same adjustment there in the PIL also?
Yes.
Yes, that is only here, my lord. We are not. We have. It was. It is on record of the 2 submissions, Lordship, at this stage.
2 submissions. Oh,
One is, my lord, that the PIL has been filed not challenging the SMC. It has nothing to do with the SMC constitution. It is only on the issue of roster system, which the government admits that they don't follow it. Notice has been issued. It is not on the managing committee, constitution of the managing committee, Lordship. That is one part.
what happened yesterday?
Yesterday they did not appear. No one appeared.
Awaiting service.
So that is on a different. Now here in this,
Who is this Jagesh Rava?
he is a ST candidate who says that roster should be followed. Not
You're the
only,
same petitioner for this Anwar Hussain and for this Rava also.
but in this PIL, this writ petition, this has nothing to do with the advertisement. That is why I have not. I have not
From
even.
here.
From this court.
Then we vacate it. Since you're seeking remedy elsewhere.
Lordship, I have nothing, as I stated, my lord, that this additional, I have not filed a miscase to stay the operation or to advertisement. The Lordships have been pleased to say that It will be subject to the outcome.
Advertisement is
What they have to satisfy, my lord, I am.
Installed.
But it didn't mention.
1 second.
The subject matter here is,
1
my
second.
lordship, please.
Lordship's interim order is which is order dated 9/3/2026.
And that has been disclosed in the PIL.
This happens quick succession. Why anyway? We'll not say why you file PIL.
That's
but the
only
same
on the
thing.
roster.
The submission you make. This is made by Mr. Day.
No, on the roster.
After
Yes.
Mr. S. Deal and counsel has apprised the court, the management committee has floated 3 advertisements in quick succession. That is on so and so and so and so for 3 teachers posts at school. This submits the issuance of advertisements in quick succession, the oblique motive to circumvent the reservation policy of the state, also to cause appointment before a regular management committee is put in place.
Yes.
Then?
So my writ petition is not on that, my lord.
Then it's reservation only, you saying?
My writ petition has nothing to do with the advertisement, lordship. If lordship would see my writ petition, my lord. I have not.
No. It's not that. The thing is that you're challenging the manner in which the advertisement is floated, not the advertisement per se, right?
Lordship.
Then?
And
so why you want for PIL now?
No, in my PIL, my lord, it's a completely different petitioner. He
You file affidavit then.
Now here, this writ petition is
You're
only
cooking your own goose. So
only confined to the, my lord,
foreign spray for and allowed
SMC
foreign
constitution.
to file. We will not make any remark on this. To file affidavit.
And it's disclosed.
If you're trying to put too many,
No, I'll disclose.
pots under fire.
Disclose, lordship. It's not nothing like that, my lord.
17.
Obliged, my lord.
Obliged.
Your Lordship, as per the last order, Your Lordship, the state respondent is directed to contact the respondent number 3 and 4.
Yes,
Lordship, I'm seeking a little bit more time for receiving a report from them, a written report, for placing before your Lordship.
No, but the thing is that your police received any information from their counterparts?
No, Lordship. As far as the Meghalaya police is concerned, they have no idea. My instructions are that there's nothing on the NCCRP portal either. So they couldn't get an acknowledgement from the NCCRP portal. So your Lordship had essentially said that I should get in touch with the respondents 3 and 4.
3 and 4, yes.
Yeah, I'm seeking a little bit more time to get a written report from them to place before your Lordships.
Have you found out what the disputed amount?
Lordship, the disputed amount, again, it's there's no other direction. We have not received anything from the concerned cybercrime to unfreeze the account.
Lordship,
that you don't know what the amount which is to be held in lien.
That information also was not provided by this concerned authority.
Lordship, that will be in the report which I shall provide to your Lordship in due course, if I may have some time.
It submits that the steps have been taken to contact the counterparts. They yet to receive any specific instructions. He further submits that on this, if such instructions receive the disputed amount, will surely be there will be known. Yes, this is the matter after 2 weeks for instructions. Ms. S. Marpan also. Yeah, we file affidavit.
Not.
To file affidavit in the meanwhile, yes.
Wait for what?
For so and so. Yes.
18.
Your Lordship, item 18 to 28 are all connected and similar matters, and is related to service matter pertains to regularization. The respondents are yet to file an affidavit.
Yes, my lord. This is my third ask, my lord. I need just 1 week's time. They're connected matters, my lord. We're preparing the documents. We're preparing the annexures. We'll file them in a week's time, my lord.
Item so to how much to how much?
18 to 28.
18 to 28.
MS, we are bringing all the matters.
Yes, my lord.
Let you place all out further 2 weeks' time. File affidavit expected next date. The officer should be on board. Yes.
29.
May it please your Lordship.
Yes.
At the outset, my apology to the Honourable Court, your Lordship, for not remaining present physically on the last date of hearing, your Lordship. Though I was present virtually, but somehow my camera and my microphone could not get switched on.
Yes, okay. Yes. What's it for today?
This is for, notice was issued on 27th of March, your Lordship. And so far no reply has come.
Who is appearing for whom?
But I am appearing for...
Today I am entering appearance for private respondent number 5, Lordship.
Any interim orders are operating?
There is no interim order, Lordship.
Number?
Respondent number 5, Lordship.
1 second. Number 5, Rangers Credit Service. Now, Dr. Mozika appearing for 1 to 4.
My lord,
1, 3 and 4.
2 I don't have. 1, 3 and 4, my lord.
1, 3 and 4.
Yes, my lord.
What about 2? They've been served.
Yes, they have been served. Process was filed and I...
No, they haven't been served as yet. What's it for today? For affidavits?
For affidavit.
Yes, Mr. S. Pandey has entered appearance on behalf of respondent number 5, and Dr. M. Mozika, Leonard Yesi is present on the respondent 1, 3 and 4. However, the service on respondent number 2 is yet to be completed. How long you want to file affidavit?
3 weeks.
Yes, sir. Prayer is made on the with Dr. M. Mozika. So Mrs. Pandey pray about 3 weeks time to file affidavit. Just after 3 weeks for service report on number 3.
2.
No, number 2. No, this
Gem is number 2.
the gem is
Number 2.
Number 2, yes. There was a miscellaneous slap application also coming with, in that notice may also be issued, and if...
This case is for?
My lord, that has to be rejected, my lord. This is the second round of litigation, an earlier round of litigation challenging the same tender, my lord. And
we have prayed in this miscellaneous application
for stay was rejected by a very detailed order.
Also, notice on this application, on this instant misapplication on the respondents to file objections.
My lord, objection is not required, my lord. I'll only submit 2 things, my lord. This is the second round of litigation after withdrawing the first writ petition, my lord. When the first writ petition was filed, after detailed submissions, my lord, a detailed order was passed by lordship rejecting the interim, my lord.
Okay, where's that order?
That is the first aspect, my lord. Second aspect, my lord, the order is of the work order is of July 25, my lord. We are in May 26 now, my lord.
My learned friend is not correct. There was no detailed order as such.
Very
When the first round of litigation, lordship, what had happened?
No, but if it's for the same period,
Same tender.
whether the detail or detailed order has been rejected.
No, it was withdrawn with liberty to file a fresh lordship on the basis of fresh cause of action, lordship.
Is
On
it
that
on a
basis,
basis of fresh cause of
that is
action?
mentioned in
Or
the
is it
order itself.
challenging the same tender.
Yes, but there was no order on the merit, lordship. The matter was ripe for the hearing. In that meantime, lordship, the respondent issued the award pursuant to the same vitiated contract evaluation process, lordship. That necessitated the claimant, petitioner, to withdraw the petition with the liberty, seeking liberty. That was 18th August 2025, lordship, and it is placed on the...
Is then writ petition?
Very detailed order.
Yes, it is also placed in the writ petition, lordship. Page number 320, your lordship. 320 to 322.
320.
Order is on page 321. May I read, lordship?
321.
Yes.
It reads, Mr. Harsiad, learned counsel for the petitioners, pray that he may be allowed to withdraw the instant writ petition as there are other developments that have since occurred with liberty to file afresh. The same is not objected by the learned counsel for the respondent. Accordingly, the matter stands closed and disposed of on the withdrawal, however, with a liberty to file afresh if any cause of action arises.
I'll kindly see the order, my lord. The interim prayer was rejected by a very detailed order, my lord. 11,
So where is the detailed order, your lordship?
Kindly see 11/4/25, my lord.
Yes.
If I may read, the matter has been posted today for consideration of interim orders. As earlier it was adjourned due to the fact that the learned counsel for the petitioner sought time to obtain instruction on the affidavit filed by the respondent. I can skip all this part, my lord. The submissions have been recorded. Para 5, my lord.
Yes.
This court has duly considered the submissions made by Ms. P. Roy, learned counsel for the petitioner, has also examined the materials that are available on record. It is a settled law that courts sitting in the writ jurisdiction will not sit and appeal over the findings of a tender committee, especially when there are no glaring irregularities or illegalities which might have resulted in a vitiated process. In the instant case, the challenge only on the technical evaluation made by the tender committee, and the point that has been raised is only with the award of 2 points on the question of a single contract, which the petitioner feels if the same had not been awarded would have tilted the award in the contract in favor of the petitioner. As such, therefore, in view of the limited challenge, there being no glaring illegal, no prima facie case.
What was the relief Lordship, what was the relief prayed for in the miscellaneous application?
Does it concern the same tender, yeah, Mr.?
I'm Abhay Das.
Yes, Mr. Das. Does it concern the same tender?
Yes.
New miss case. Then sorry, miss case 108.
No. All I'm kindly see my prayer in my miscellaneous application, Lordship. Kindly see, just for a second, Lordship.
I'm sorry.
It reads, kindly see. I'm only saying that the award that was passed in this contract that was awarded should be treated temporary interim. There I was seeking a stay on that evaluation, Lordship. So these are two entirely different things.
The work order was awarded after that was challenged, my lord.
No, the things that see, Mr. Das, after the award was given, that is in 25.
Yes.
Correct? Now we are sitting in
2026, Lordship. Then? No, I am stating simply you don't treat that as final. I will demonstrate from the contract condition itself that at any point
we'll take it together the main case.
It's not a case for interim now at this stage now.
No interim orders. Miss case also.
Notice may be issued, Lordship. They may take the objection, Lordship. Then an order may be passed.
Unnecessarily complicate the matter. I have to file a reply to that one.
Also, this matter will
come together with
the main case. Well, list after 3 weeks.
Hearing. Supplementary list 5.
What is the date?
May it please, Lordship. Lordship, the case in petitioner before your Lordship is challenging the decision of the cantonment board, my lord. Yes, this challenging the decision of the cantonment board, my lord, whereby cantonment board rejected the application of the petitioner for renovation of the bungalow, my lord. That's a sort renovation of bungalow.
Renovation of bungalow?
Bungalow, because the permission has to be given by the board, and pursuant to permission, the petitioner gets entitled to renovation of bungalow.
By
the board, my lord. That, yes. By the board.
Yes.
Now, my lord, before I take your lordship to the various issues, my lord, one issue which is there, my lord, that under the Cantonment Act, my lord, there is a provision for filing the appeal. Appeal was preferred before the board, my lord. Board passed the order directing the authority, appellate authority passed the order directing the board to take a decision on the matter, my lord.
Where is that?
That your lordship, if I am having a small list of dates, my lord, if your lordship will straight away, but before I take your lordship to the dates, to the order, my lord, kindly have the list of dates. It will, and if your lordship will see, yes, my lord, this list of dates, my lord. For serial number first, my lord, is the date of original lease agreement, my lord. Page I have already stated, my lord. Now the relevant lease deed is, my lord, if I come into picture, my lord, in serial number 3, my lord. That is at page 2, my lord. Registered sale deed executed whereby leasehold right in bungalow number 33, survey number 32, sold to late Motilal Jhunjhunwala for consideration of 2 lakh rupees, my lord. Then lease was executed, my lord, by the authority on 25th August 1997, which is expiring on 30th June 26, my lord. Yes. On 4th March 1991, mutation was effected in the name of late Motilal Jhunjhunwala, General Land Register, Survey Number, Shillong Khand. Now, on 26 December 1994, Ministry of Defence sanctioned acquisition. Now, the order was passed by Ministry of Defence. Acquisition of leasehold rights of bungalow number 33 for military use. Acquisition proceeding initiated by State Revenue Authorities, my lord. On 29th March 1989, notification number 4 of Land Acquisition Act challenged by petitioner in civil rule before the Honorable High Court of Guwahati on ground of absence of public purpose. On 10th March 1992, Honorable High Court quashed the declaration under Section 6 of Land Acquisition Act and directed hearing of the objection under 5A. On 16th February 2000, serial number 9, my lord, Honorable High Court in Civil Rule number 437 of 1990 set aside the first declaration under Section 6 of Land on the ground that collector's report recommending dropping of proceeding was not considered by the appropriate government, my lord. Note, my lord, On next page, acquisition proceeding quashed in the entirety, no valid acquisition proceedings subsisting, thereafter petitioner's leasehold right remain unaffected, enforceable. On 27th January 2006, Government of Meghalaya sought clarification from military authorities regarding utilization of previously acquired properties before initiating fresh acquisition. No reply furnished by local military authority despite multiple requests. Inaction on the part of military authority resulted in stalemate, cannot rely on long quest acquisition proceeding to deny a statutory right of lessee under Cantonment Act 2006. Now on 10th March, my lord, I filed my decree for eviction was passed in title suit in favor of.
What title suit is it?
Because I filed a title suit, they were occupying despite leasehold rights because they were occupying my bungalow, my lord. So I filed a title suit. I got the title suit was decreed in my favor, my lord, on 10th March 2004, my lord. The orders are at page 1 to 127, and on the ground of fraud and finding a favor of Motilal on the ground of rough and negligent use of property by military authorities, finding of prima facie established, decree attained finality after exhaustion of appellate remedy. Then, my lord, on 15th April 2004, RFA by Union of India dismissed by additional district judge, defendant not proper care despite multiple occasions, buildings, my lord. First appellate court at page 5 affirmed the trial court decree, no merit in challenge to petitioner's title right of possession. On 24th September 2007, my lord, RSA dismissed by the Guwahati High Court and decree attained finality in 2007, exhaustion of all appellate remedies, petitioner right to possession and enjoyment of property is conclusively established. On 28th April 2005, my lord, the filed by writ petition filed forcibly dispossessed petitioner's family. Honorable High Court directed restoration of possession, my lord, on 28th April, my lord. Remedy revoked on 15 my lord. 31st May 2005, possession of bungalow handed over to late Motilal Jhunjhunwala in severely dilapidated condition pursuant to Honorable High Court order in writ petition 127 of 2004 as recorded in the handing over taking of property rendered uninhabitable due to prolonged neglect of military authorities. A positive obligation under 1.7 of lease agreement and section 235 of Cantonment Act to carry out repairs arose immediately, my lord. On 27th September 2005, first application for NOC for renovation to Defence State Officer Guwahati Circle by Motilal Jhunjhunwala was submitted, my lord. Commencement of bona fide effort to comply with the statutory and contractual obligation, my lord. On, my lord, that not happened. Again on 10th February 2015, my lord, notice under section 235 of Cantonment Act submitted to Cantonment Board for erection and re-erection of bungalow number 30, exercise of statutory right to seek sanction for repair, re-erection of bungalow, bound to consider application and pass order under 238.5. I will take your lordship to these two sections, my lord, which are fortifying my right, my lord. On 10th March to DEO, District State of Guwahati, Defence State Officer Guwahati Circle informed that NOC permission for repairs not required during lease term under clause 1.7 of lease agreement read with 238.3 of Cantonment Act provided no change in authorized plinth area. Recognition of petitioner's right to carry out repair without NOC, subsequent reliance on absence of NOC by Cantonment Board legally unsustainable. On 4th May 2015, DU forwarded legal opinion of Ministry of Law Justice opining that leasee is entitled to enjoy property up to lease expiry, that is 30th June 2016 in habitable conditions. Legal opinion with respondents affirming petitioner's statutory and contractual rights. Respondent cannot act contrary in binding legal without recording reasons. On 7th July 2000, Canton Board resolution, building plan returned unsanctioned, my lord. This is the petitioner directed to submit exact repair details, informed that permission for repair shall not confer right to claim continued possession post 2026. Conditional observation extraneous to the scope of 235 and 238 of Cantonment Act cannot impose conditions not contemplated by statute. Right to repair distinct from right to possession. On 31st July 2015, fresh notice under section 235 submitted with detailed repair plan, cost estimates complying with board direction. On 14 December, board acknowledged property under DEO management, lease between Government of India and lessee, board concerned only with building bylaws, permission granted to carry as per lease terms, my lord. Express authorization to proceed with the repairs, petitioner entitled to rely upon board's resolution, subsequent stoppage arbitrary and violative of legitimate expectation. On 22/2/2016, DEO permitted the continuation of renovation of work as per clause 1.7 of lease agreement and section 235 of Cantonment following joint Concurrent authorization by both statutory petitioner entitled to proceed with repair in reliance upon express permission. On 16th May 2016, notice under 241 of Cantonment Act issued alleged unauthorized construction demolition directed. Abrupt reversal without recording reasons, allegations contradicted by prior joint inspection report, violation of principle of natural justice. On 24th August 2016, Board Resolution number directed petitioner to submit fresh notice under 235 of erection and re-erection, issuance of notice under 320 of Cantonment for non-compliance of earlier direction. Implicit recognition that earlier objection not sustainable, continuous mechanical application without substantive consideration. On 3rd September, now Milord, this is the fresh round of litigation which your Lordship is concerned with. On 3rd September 2016, fresh notice under 235 submitted with undertaking to demolish temporary shade and maintain original print area. On 16 July, petitioner issued notice under 238(6) of Cantonment Act claiming deemed sanction of erection re-erection due to board's neglect omission to decide on notice dated 3rd September 2006 without statutory period. On 12th, Milord, again 12th September, I was objected.
Long and short of it is that through the entire
period, yes,
in period. Now, after you were restored possession,
I was not allowed to
for renovation and for reconstruction.
And I was not allowed at any point of time. That's a long and short, Milord. Only 2-3 dates are more important, Milord. I'm just finished, Milord. Now, Milord, Lordship will skip all these parts, Milord. Kindly come to, Milord, the Lordship's, because your Lordship has seen serial number 26. Your Lordship may mark serial number 26, 39/2016. That is the serial number 26, Milord. Yes, Milord. This is my application. Yes, Milord.
Okay, yes.
Then, Milord, your Lordship will find that remain unsanctioned. That is serial number 28, Milord.
Right.
And then I approached this Honorable Court on 8/12/2017. Liberty was granted to approach appellate authority under Section 340 of Cantonment Act by this Honorable Court. On 13 December 2000, a statutory appeal filed before General Officer Commanding in Chief, Eastern Command, Milord. On 27/11/2018, appellate authority allowed, Milord. And now, your Lordship, kindly see my appeal. This order, Milord, kindly see at 256, Milord. Direction at 256, Milord. Page 2.
So this GOC&C Eastern Command he allowed.
Yes, Milord, and issued fresh direction. And I am taking your Lordship to that.
The GOC&C is in Fort William, right, in Calcutta?
Calcutta, yes, your Lordship is right. It is there, Milord. And relevant page your Lordship will find at 256. The order starts, Milord, at 245, but relevant page your Lordship will find at 256, Milord.
Yes.
Paragraph 11. In view of the above, the following directions or orders are passed. Appellant to give fresh notice of re-erection of bungalow under 33 under Section 235 of Cantonment Act, together with complete building plans and sketches, details of material to be used, as well as detailed cost estimate of such re-erection to the Cantonment Board, Shillong, within 1 month from the date of receipt of this order. Appellant shall render an affidavit of undertaking regarding effecting the erection or re-erection of the said bungalow under 33 on survey number 32 of Shillong Cantonment at a reasonable cost as per its original specification and character of the Assam Time building, with no change in plinth area and cubic capacity of each room, and where it existed before its demolition by the appellant. Undertaking shall also state that appellant shall cooperate in peaceful resumption of leasehold property after expiration of the said lease in the year 2026 to the Government of India, without seeking any compensation for the expenditure done by appellant on re-erection and on erection or re-erection of building as per sanctioned building plan. Third, Cantonment Board shall process the case. Milord, kindly mark. Necessary NOC of DO under the Cantonment Act. DO Circle will process the case in accordance with provisions of 238(3) of Cantonment Act within the time limit of 1 month stipulated therein. DO Guwahati Circle shall in its report of Cantonment Board under 238(3) specifically comment upon issue of requisition of property with respect to station journal plan, the status of resumption proceeding, as well as security related observation by LMA Station, Shillong on 24th August 2017. Upon receipt of report from the DO Guwahati Circle, Cantonment Board Shillong will consider the permission for erection or re-erection of bungalow through a Cantonment Board resolution, and detailed minutes of especially the aspect of incurring substantial expenditure by appellant in re-erection within period of 1 month shall consider the violation of 247 of the Act by the appellant in causing demolition of bungalow 30 without obtaining requisite permission. So this was the direction passed to the board, my lord, and board decision which is impugned, my lord. Because what has happened, my lord, that there was nothing was moving, my lord. This decision was also not coming. So I came here, my lord, in the writ petition at 257, next page, my lord, before your lordship.
Yes.
And then this honorable court on 3rd December 2018, my lord, in last page, last paragraph on perusal of para 9 of said order. In para 11.8, it appears that after considering the facts and circumstances of the case, they were of the view that a fresh application is to be made to the Cantonment Board Shillong, and Cantonment Board Shillong will consider the matter and take necessary steps. If so, petitioner is directed to take necessary steps as per 11A of the appellate authority and Cantonment Board to dispose of the matter in fair matter. After that, if petitioner is any way aggrieved, he may approach the appropriate forum in accordance with law with the observation and direction writ petition stand disposed of. So this was, my lord, I was directed to approach this honorable court, my lord, and on 20th, my lord, serial number 33, my lord, on 20th December 2018, my lord, in list of dates at 43, I filed the undertaking, my lord, which was directed by the appellate authority, and I also gave a fresh notice on 1/1/2019, which is page 263 to 268, my lord. Then there were certain observations which were given by CO at serial number 35, my lord. CO returned building plan with observation for resubmission. On 36, my lord, on 17 January, revised building plan submitted complying with all observations and direction, my lord. Now, then, my lord, this is the board, my lord, on 26 to 2019, Cantonment Board forwarded everything, all these reports to their officers, my lord.
One thing, Mr. Arvind,
yes, my lord.
Mr. Kumar here.
Yes, ma'am. Yes.
The thing is, the lease is expiring on
26, my lord. 30th. Now the issue is, my lord, that lease is expiring.
Now what's happened? Have you been application for renewal?
No, my lord. We have in all over India, my lord. What is happening that it is expiring?
They are reorganizing
yes,
the entire country.
Entire country, my lord. So then, the undertaking I have already given, my lord. I have there in terms of appellate authority that if there is cost anything. If the lease is terminated, I will not claim any cost. I will not claim that undertaking. I have already complied with the applicant. Now, kindly see the impugn order. Kindly see impugn order. That impugn order is in gross violation. At page, lordship will find 451, the impugn order. $451 million. Yes. Lordship, this is the order, this is the minutes of the meeting of the board which was communicated to me, my lord, and the board, my lord, is 453, my lord, and relevant part of the board resolution, whereby my application, only 3 lines are there, my lord.
Again, 54?
454.
Annexure 54?
Yeah, no, annexure is, my lord, yes, 54, my lord. Sorry, annexure 54, my lord. That at 54 at page 454, my lord. Resolution. The matter was widely deliberated by board. Board took note of stay order in the requisition proceeding Guwahati High Court, that later number so and so. The Bothra elected member is of the view that sanction is to be sued with condition keeping in view of the order of the appellate authority dated 26 November 2018, my lord. Now board finally considered and rejected the building application. No reason whatsoever is given, my lord. And I'll
rejected this was on?
The board finally considered and rejected the building.
19?
Yes, my lord. I am coming to that part also, my lord. 19, what happened after 19, my lord? My lord, kindly take note of the reason, my lord, and delay part. I will both. The board passed this order. Now, my lord, I moved the contempt petition, my lord, before your lordship at page 456, my lord. Page 457, my lord.
Yes.
Contempt, and at 457, paragraph 6, Your Lordship may have it. Paragraph 6. 5 and 6. In fact, clearly observed, the petitioner is anyway aggrieved by decision taken by Cantonment Board on his application, he may approach the appropriate forum in accordance with law. No case for contempt is made out. Petitioner is dismissed while reiterating the aforesaid liberty to the petitioner to assail the order passed by board if he so advised in a fresh writ petition, my lord. So this liberty and this order, my lord, attained finality, my lord. What has happened, my lord, that on an advice, my lord, which was, in my opinion, it was not, the suit was filed by the party, my lord, and suit was ultimately, at your lordship will see, because that is the objection taken by the respondent, my lord, suit 460, your lordship will find the suit's order, and 462, my lord, suit was withdrawn, but the learned trial court, my lord, had
Yes.
in the 462 bottom, my lord, refused to grant. In view of the above observation made, this court is inclined to allow the prayer of the plaintiff to withdraw the instant suit, but is not inclined to allow the liberty to file the suit afresh on the same subject matter. So the trial court refused to grant the liberty to file a suit. My submission, my lord, is that so far as delay aspect is concerned, my lord, this is a continuing wrong, because I am the leaseholder of the property, my lord.
No, but a rejection where came at far back.
In 2019, my lord, it came on, if your lordship will see, that in my serial number 44, my lord, is a case of continuing cause of action.
Whatever it be.
I mean, my lord, if your lordship will, it's a right to hold the property, my lord. Because what has happened, I went to the court, my lord.
So the thing is that it's a totally dilapidated condition.
It is dilapidated. I can't use it, my lord. And this right, I have a right under Article 300A, right is a continuing right, my lord. This, and the suit, I was told, my lord, that withdrawn, that there was some sort of compromise at that point of time. Promise was made that since you withdraw, we will take care. But those are not on record. I can't place it on. But this is the backdrop of the facts, my lord. Now kindly see section 235, because your lordship has seen the yes, two things your lordship will see. Direction has been passed by the appellate authority to pass the order in terms of the statutory provisions, my lord. Now kindly see section 235, my lord. 238, I'm sorry, 235, sorry, 235, my lord.
Yes.
235, notice of new building, my lord. Whoever intends to erect or re-erect any building in a cantonment shall apply for sanction by giving notice in writing of his intention. Where such erection or re-erection is an area other than civil area, to the board. Where such erection or re-erection in civil area, to the chief executive officer. We are concerned with, my lord, 235(1), my lord. 235(1)A, because it is in the board area, my lord. Now, 2, my lord. For the purpose of this section, a person shall be deemed to erect or re-erect a building who makes an material alterations, converts human habitations, my lord. We are not having any issues on this part, my lord. Now kindly see 238. Then, my lord, kindly come to the 238 power of the board, my lord. Power of the board at 238. 235 is the application. 238 is, my lord, power of the board, my lord. Power of the board to sanction or refuse, my lord. Board may either refuse to sanction the erection or re-erection, as the case may be, of the building, or may sanction it either absolutely or subject to such direction as it thinks fit to make in writing in respect of all or any following matters, my lord. So kindly mark, my lord, this the mandate of the law, that may sanction it either absolutely or subject to such condition as it thinks fit to make it in writing in respect of all or any of the following. Now conditions is, my lord, free passage or way of left building. So these are the conditions, my lord. So the board is required to sanction either absolutely or either absolutely or subject to conditions, my lord. A board has no power to say that I will not grant you, because if I
But
meet
the fact remains that he's challenging a 2019 order now.
2019 order with pursuant to liberty granted by your lordship in contempt petition, my lord, and my right, I have got 3 judgment, my lord, recent judgment also, that it is a case of continuing wrong, continuing wrong, my lord, and your lordship will, and lordship, the purpose of showing entire list of dates was that I have got this leasehold right and I have been struggling to re-erect this building since 1985, my lord. Your lordship will, and if there is a delay on my part, my lord, there is a delay on their part also, time to time, in not sanctioning and refusing on one ground or the other, my lord. So when it comes to balancing,
But I saw that one regarding reconstruction, some illegal construction was done by
they
you.
have said they will fine, they impose fine, we will pay the fine, and we paid also, we will pay the fine. That aspect, my lord, I am not contesting. I am not, because that is, the order is binding. I have suffered that order and I have got benefited from this order. Now, my lord, so therefore my case is, my lord, the lordship has seen the order of the board, completely non-speaking. Appellate authority's order is very clear, and 238(5), my lord, your lordship will kindly see, this is, there is a provision of deeming sanction also. Kindly see 5. If the board decides, 238 subsection 5, my lord. If the board decides to refuse to sanction the erection or re-erection of building, it shall communicate in writing the reasons for such refusal to person by whom such notice was given. 238(5). And your lordship will kindly see the order, impugn order once again. 254, my lord. 454. Page 454. 238 subsection 5. And kindly see, my lord, 454 region. The board finally considered and rejected the building application, my lord. One line.
When was the suit instituted?
Nothing.
When was the suit filed?
Suit was filed, my lord. Suit was filed in 2022, my lord.
Even the 3 years after the.
Yes, my lord.
Board.
The board suit was filed in the 2020, my lord.
Okay. This can't make out. Yes.
Yes. So if you lordship kindly come page 460, my lord. I should have page 460. It is mentioned, my lord. Case number
13/2020.
Yes, 2020, my lord. It was filed in 2020, my lord. I stand corrected. So it was filed in 2020, my lord. My lord, I have 3 authorities on this point, my lord.
Yes.
First, my lord, before I take your lordship to the authorities, my first ground is, my lord, that the order has been passed in violation to the order passed by the appellate authority. Appellate authority has mandated that you will grant the sanction. And you will grant the sanction only, and you will consider and grant the section. Second ground is that the order is passed in gross violation to section 238(2) and 238(5). Okay. This is the second ground.
Limiting only to this repair. And what you have to do.
Renovations, my lord, my application is there. They will consider and they will pass the order. And I have whatever objections they have asked in 7.
When the lease terminating?
Is in June 2019 or 2026, my lord.
Only 1 month to stay there.
My lord, they are not getting, because all lease are going to get renewed, my lord.
How do you say that?
Because, my lord, it's not affecting us, because we have got the leasehold rights. In leasehold rights, your lordship is aware.
No, I understand. You understand whatever rights within your lease, you are entitled to repair.
But my lord, and subject
actual facts surrounding your case.
Yes, my lord.
Is that your lease is getting over on 26?
On 26, my lord. And one point which I say that the appellate court, while directing the board to consider my application, issued direction to the board that I will not claim any cost, anything for.
That is lip service. Anyway. So
no, I will. If that order binds, my lord, that order, I can't go beyond that order, my lord. Kindly consider me how I have suffered, my lord. And your lord, it can be subject. This order can be subject to renewal, my lord.
The thing is that now, one thing you have to satisfy the court.
Yes, my lord.
With regard to your court continuing wrong.
Yes, my lord. I'm grateful.
You filed a suit. You were and pursued.
Yes, my lord.
Remedy. In the suit, what is the plain attached here?
Suit, the order is attached, my lord. Plaint is not.
What are pleadings in the plaint? Is it directed against that order itself?
Yes, my lord. It was directed against the order, my lord. If your lordship will, I can take your lordship to the order at 460.
Order in a title suit?
Yes, my lord. Order is, my lord, the section is quoted. After quoting the section at 461, my lord, I have the title suit, my lord, here. Prayer is that, my lord, declare that plaintiff and their predecessor.
Now, what impact would this have that you
withdrew and liberty was not granted? Yes, my lord. There are two preliminary objections which have been taken by my learned friend. One is delay, my lord. And
delay is very substantial.
Delay
How is it overcome?
No, my lord, delay in continuing wrong is settled law. Is settled law. If I have 3 citations.
Look at the circumstance of each case.
No, my lord, continuing wrong, because now the question is 2 things, my lord. Exercise of discretion by this honorable court and whether I have a right to come before your lordship or not. If I have right, your lordship may or may not exercise the discretion in equitable circumstances, my lord. That in equity, your lordship may or may not. That is one aspect of the matter. But to say that my right is closed, my lord, if it amounts to saying, my lord, assuming, my lord, this lease was subsisting for next 50 years. And then I am not allowed to renew because I could not have got.
Understand.
So that
we're looking at your case.
Yes, my lord. In my case, my lord.
2019, that's what weighs in the mind of the court.
Yes, and
2019, the Cantonment Board rejected your prayer summarily without discussion. You never came to the court. You never filed a petition after that.
No, my lord, I came in contempt, my lord. And contempt, your lordship said, file a fresh writ petition, my lord. Kindly see the contempt liberty.
Fine.
File a fresh writ.
But then you never.
No, but now, my lord, that liberty was granted by this honorable court in contempt matter, my lord. In contempt and liberty, I have, my lord, that order is final. That order, liberty has not.
Manta, the lease being renewal being processed.
Yes, your lordship.
Being processed, renewal being processed. It'll be renewed.
Please. No, that I cannot say, your lordship. This will expire in this June 2026.
That's what the court is saying.
That is one hurdle there. But however, your lordship, let him complete that.
I think
238, we are bound by 238 subsection 3. So DO Guwahati Circle Union of India is a necessary party into this. Very tactfully omitted.
At 235, my lord, I will.
Your lordship can see 238 subsection 3. The board, before sanctioning the erection or re-erection of a building on the land which is under the management of the defence state officer, shall refer the application to the defence state officer for ascertaining whether there is any objection on the part of the government to such erection or re-erection, and the defence state officer shall return the application together with his report thereon to the board within 30 days after it has been received by him. So they are necessary party unit there. Tactfully avoided. I don't understand.
I will meet that aspect also, my lord. Now this is
a ground also that misgender of parties.
Yes, I know, it's very clear.
Therefore, once the DO Guwahati give the objection, then we are bound to reject it. There is nothing more.
My lord, I will show that aspect also. I'll deal with 3 aspects, my lord. 3 aspects.
Then 250 also says that bar for any suit. Section 250. Because they have an alternative remedy under 340. Because this is not a continuing cause of action. First cause of action arose after they again submitted a application under 235.
Arose and rejection was passed in 2019, my lord. I will just 3 objections. I will quickly deal with all these. All 3 objections, my lord. I'll quickly deal with these 3 objections, my lord. Now kindly see, my lord, what my friend is saying. First, my lord, delay aspect, my lord, because I will deal one. My lord, so far as your lordship is aware, I am having the.
How much more time will it take?
10, 15, 20 minutes. What do my lordship?
Your lordship, even at 3, I have to be there for bar election. So that's what I informed.
Bar election?
Bar council election for the post of vice chairman of this. So, what do you think?
The problem is, my lord, my lease is expiring.
Yes,
but the
matter
lease
is very simple also. But see, the only thing we have to look at your conduct also, and how you know the
no, my lord, I will
whole litigation's progress.
no, my lord, kindly weigh the conduct of both the parties, my lord. That would I say.
We will weigh kind of
and
but if there
that is one
if
aspect.
there are latches on your part,
yes, my lord,
which then
your lordship has applied this law of latches in number of cases, my lord. What is the principle? Principle is that, for example, my lord, in the cases where I have a right to continue in possession, my lord, I have a right to be in possession.
Your right to be in possession till June 2026.
No, that is the second aspect, my lord, because that possession will not be disturbed. If it is disturbed, it is at my cost. It is that aspect. It is my right to be in possession of the building is there.
So, suppose permission is granted.
Yes, my lord.
That you
and
re-erect to renovate the bungalow.
Yes, my lord. And I renovate.
Permission is subsistently during the subsistence of your lease, correct? Suppose you build the bungalow half.
Yes.
And your lease expires.
No,
can they come and say stop?
No, then my right to the permission can be granted subject to renewal of lease, my lord. And what I'm saying, I'm not saying that don't grant, but the issue is, my lord, I have been struggling.
That means it becomes the cart before the horse again.
No, my lord, because
if you asking for permission conditionally on anticipation or apprehension that it might be cancelled or anticipation will be renewed.
Because this is the policy decision of the. Let them come with the policy. There is a policy decision by the government of India on these issues. I am not the only one who will be there, my lord. If they say that no, all leases are to be terminated, I am out, my lord.
Will it come in several areas now? No. If see there's a revamping.
Yes.
With regard to certain areas, it'll be given to civil authorities.
No, this is not class C, land. This is an army land. There's a drawbacks with us. So without the DO Guwahati, we are nobody.
The issue is, my lord, the board has. I'll just kindly see what my DO point, my lord. My friend is repeating. Kindly see the impugn order again, my lord.
If your lordship permits on Monday, no inconvenience, because
we can do it now. My friend is.
Yes.
Monday
you'll be here.
Monday I will do it online, my lord. I have to. Some book launch is there by Solicitor General on Sunday evening.
Yes. This for further hearing on Tuesday.
Tuesday.
As you.
Yes.
I'm sorry for the inconvenience.
No. This we all have our own.
And my lord, authorities after authorities, I will place on the continuing ground, my lord.
This
even
is
this court, your lordship knows.
This is a well beaten.
No, the beaten path.
Regarding its cantonment matter with regard to 235 to 340.
Yes, my lord. I had occasion to go through it for the first time with the help of the.
And then Mr. Mantal, I was many matters also done. Even Fort William when it appeared, that was many years ago.
Before the appellate authority.
Also have to go that Asmara case, I still remember. 340 council.
We succeeded.
So this is my experience.
Much.
Yes.
Election petition matter, my lord. Item 30 minutes. In this matter, my lords, we have applied for the certified copies of
it was filed by you. Okay, we'll adjourn it for 2 weeks for the reasons stated here in this.
Yes.
31.
What instructions have you received?
Lordship, there was a...
Only with regard to the office order 42 years.
Lordship, we have written to them twice. We are yet to receive any replies. That is the only difficulty, Lordship. As late as on 16th April also, we have sent them a reminder.
This has been since from June 2025.
We'll call him to come here.
Or the secretary, perhaps because...
Or the secretary.
Lordship is aware.
After 1 week.
2025 or so, last year,
on
June or so.
Musical chairs out there, what can we do?
Lordship. He's...
No, actually, in my rejoinder, I have there saying that.
Very good, yes. We are aware of that. Yes.
Bring some 2 weeks, Lordship.
2 weeks, okay.
Published.
Yes.
Much blessed, Lordship.
33.
Please, Your Lordship. Your Lordship, the respondent had to come with instruction in this matter, Your Lordship.
Lordship,
Where's the respondent? Ms. Ibra is present on behalf of the petitioner. None appears the respondent. What comes instruction list after 1 week? Yes. Oh, you've got instructions or not? You have received instructions?
Lordship, actually on last occasion the matter, order was passed that the matter is admitted and it is fixed for hearing. Lordship, and
don't play these games.
No,
you know very well
Lordship.
you can't take two stands.
No, Lordship.
One. You can't make a submission. First time you have taken a different stance in Delhi High Court and taking
Yes,
stance here.
Lordship.
Yes.
Yes,
So don't-
Lordship. I
don't
have
make a
taken that.
submission advert for hearing.
No, Lordship, it is actually, Lordship, I was little confused. That I am admitting it is my confusion because in the order itself it was reflected that it is for admit. The matter has
This matter.
Yes, Lordship. So I am confused. Like since it has come as an
Okay, we'll hear
hearing.
it.
Lordship, the instruction of Delhi High Court is yet not has come, but Lordship, the particularly what 7I has stated, Lordship.
No. See, the only thing is that since you're the same authority,
Lordship.
you're a regional provident fund organization, whatever.
Lordship.
In Delhi High Court, you said you took a different stand. Here you see it's severable. There you see it's not severable. You've gone an appeal against the
Lordship,
finding. You've gone an appeal on Delhi High Court. So
Yes, Lordship, we have gone on
you
appeal
don't
on.
have a chief provident fund commissioner who's taking a call on these matters. In one High Court, you take different stand. Next High Court, taking different stand.
No, Lordship, it is
No.
not.
Nobody take a stand.
Lordship, we will be taking a we will be taking stands on a similar footings, Lordship.
Stand after the what's happened to the appeal in Delhi High Court? Disposed of.
No, Lordship, it is not
Then
yet disposed.
That's why. So you're putting you're sitting in two boats simultaneously.
Lordship,
Taking your chances. If a verdict comes from here that is severable, then out there you said it's not severable, then
Lordship, irrespective of separable or not separable, Lordship, I am apprising is that my only first submission, which I initially took the submission, this judgments has come subsequently. But what my understanding of the act is that, Lordship, when 7I has given me an opportunity to go for an appeal. And
and 7Q
in
has
7I, 7Q is not mentioned. More so.
But then the stand you've taken in Delhi High Court is different.
Lordship, if
you take the same stand there,
Lordship,
that even if 7I and 7Q contain passed on the same day, the order has been passed the same day, that means they both be appealable. Then fine. If you take the stand, Delhi High Court, now you take different stand here. There's only confusion. You have created confusion to the court. Not confuse yourself.
Lordship, just give me 1 week time, Lordship. I'll come next week, Lordship.
Okay.
I'll come next week. I'll have a talk with the counsel from Delhi High Court. I was trying to get through the counsel from Delhi High Court. So I'll.
See, this is the dilemma that you're having, because they have brought on record that judgment of Delhi High Court. That's appealed by you,
Lordship,
saying that it's severable. 7I, 7Q, and out here you're saying they're not.
They are saying they have placed the judgment of Arco Textiles, which saying that they are not composite of each other. And for me, I am saying that yes, both are composite of each other. They are not separable.
You are saying they're not composite there. You're saying the composite here. That's the whole thing, right?
Lordship.
That's the only thing.
Lordship, I'll
yes.
give me
After 1 week.
Lordship, the interim may continue.
You know, whatever you continue is only small thing. And if you say the composite, will make it go for appeal. If you see in Delhi also is composite, then we'll make it go for appeal. If you say it's not composite, then you go and tell them Delhi that's not. We withdraw your appeal in Delhi High Court.
Lordship, because Delhi High Court has already made an observation to go for CGIT, Lordship. In Gaurav Textiles,
yes.
They have made an observation to go to.
You come prepared.
Lordship.
Yes.
My lord, in this case, I pray for little accommodation. Let this matter be fixed in the week commencing from 18th.
What is it?
This is
for?
arbitration matter.
Only here what happened, my lord? Earlier,
Section 34 order.
originally the award was 2.5 crore rupees. We have and they forced us to deposit the amount, my lord.
Oh yes, sir.
We deposit in the commercial court now. Now the award has been modified, my lord. Now they are only entitled to 90 lakh rupees something. Now we are unable to get that money because of the pendency of this matter.
My lord, they themselves are challenging. They have also filed counter appeal.
Monday.
Not this Monday, but 18th Monday.
It is, they should release the money, my lord. I have no problem.
They are also challenging the appeal.
They'll only get the money which they are entitled to under the decree, my lord.
Okay, 18, yes.
18?
Two strong objections has been, today MS Piri Bazabarwa, Learned Senior Counsel on behalf of the petitioner, has paid some accommodation due to personal difficulty and prays that the matter be fixed on the 18th.
They should refund the money.
Strong objections have been raised, Nekvara and Mozika, who submits that
the modified award
substantial sum of money is being held
that
up.
matter is pending in the execution.
Award being modified.
That order of modification, they have also challenged, they have also filed counter appeal, my lord. So how can they claim on the basis of that?
Yes,
they themselves have filed appeal.
On the prayer list, prayers allowed list on the 18th.
Only one of the pendency will not be a bar for release of the money.
On the last occasion, your lordship has already passed order. It is pending in executing court, my lord.
It's almost now.
18, we can take up the matter for final hearing.
If we not taken up, still there will be direction.
It is a connected matter, both 35 and there is a counter claim, my lord, or the counter appeal. That's 6.
We are not getting interest on 1.5 crore rupees stuck like that.
Yes.
Obliged.
Worship, let this matter come after 1 week, Worship.
My lord, I'm sharing the prayer, my lord. Let it be a joint prayer, my lord. It may come after.
36 to 38 connected, my lord.
My lord, on behalf of MECL, my lord, here.
38, my lord.
Is a compensation matter?
Compensation.
No, my lord, this is electrocution, my lord. FEDCO is there, my lord.
Your lordship, I'm appearing for FEDCO for respondent number 4 and 5.
First time today?
Yes, I'm appearing for the first time. My name is Ishwar Mohapatra.
Yes, Mr. I. Mohapatra, because the appearance on behalf of respondents 4 and 5.
Your lordship, I'd like to file my vakalatnama.
Yes, you may put
and also the liquidation order, your lordship, of the Honorable NCLT Delhi. This company is undergoing liquidation.
You file affidavit is
Hearing on behalf of the state,
file a power and also affidavit to record what reservation order.
Liquidation order. I'll file liquidation order and your lordship.
You file affidavit. You file affidavit.
So vakalatama also with the affidavit.
Yes.
I'm assisting them. He's local counsel.
Very good.
Ekhan.
He's
Ekhan, yes. You're supposed to be you assisting Ekhan.
Yes.
Much obliged, lordship.
My lord, 3 items, 36, 37, 38.
The petitioner may be given direction that they can file their claim before the liquidator, because unless and until they will file the claim.
Doesn't matter unless you file affidavit. One that comes on record, we'll take cognizance of that and then we will pass orders.
Yes.
39. Much obliged, lordship.
Similar prayer for item 39, Worship.
Yes, after 2 weeks. MSS Irons waited the whole day for this matter. 39. Okay.
Madam.
Much.
Obliged.